Marriage is supposed to be built on trust, love, and protection. The person you choose to spend your life with should be your safest place in a dangerous world. But for the victims in these cases, the greatest threat didn't come from a stranger or an enemy. It came from the man sleeping beside them every night, the father of their children, the person they trusted completely. These weren't random acts of violence or crimes that happened in the heat of the moment. These were calculated murders that destroyed entire families, committed by men who once stood at an altar and promised to love and cherish until death do them part. And the courts made sure that promise became literal, sentencing them to death. Today, we're covering husbands who went from loving partners to convicted killers, and the ultimate betrayal that landed them on death row. What you're about to hear are the real stories of men who murdered the women they married, the evidence that convicted them, and the death sentences that followed. Case number 1. Marion Alexander Lindsay was a man from South Carolina who murdered his estranged wife, Ruby Nell Lindsay, in September 2002 by shooting her multiple times while she sat in a car at the Inman Police Department parking lot. The murder occurred in front of witnesses, including 2 young children who were present in the vehicle. Lindsay was convicted of murder and sentenced to death in 2004 by a Spartanburg County jury. The case became notable for the extreme violence that took place in what should have been a safe location, the long history of domestic abuse that preceded the killing, and the legal battles over the death sentence that continued for more than 2 decades afterward. Marion Lindsay and Ruby Nell Lindsay had been married and living together before their relationship deteriorated to the point where Ruby decided to separate from him. Ruby was 27 years old at the time of her death. The couple had 2 minor sons together, and the issues surrounding custody and access to these children became a major source of conflict between them. During their marriage, Marion Lindsay had repeatedly been violent toward Ruby. Court records document multiple instances where he struck her in front of witnesses. In December 2001, less than a year before the murder, Lindsay beat Ruby in a restaurant parking lot and then fled the scene before police could arrest him. This incident showed a pattern where Lindsay was willing to assault his wife in public places without concern for witnesses or consequences. The violence between Marion and Ruby had been documented by law enforcement for years before the fatal shooting. Court records showed that Lindsay was accused of domestic abuse incidents in August 1996, October 1996, February 1999, August 2000, and December 2001. This pattern of repeated abuse over a period of 6 years demonstrated that Ruby had been living with violence throughout much of their relationship. Despite these incidents, Lindsay had not been successfully prosecuted or imprisoned for long enough to prevent the escalation that would eventually lead to murder. The criminal justice system had contact with this domestic violence situation multiple times, but was unable to protect Ruby from the man who would ultimately kill her. On September 17, 2002, the night before the murder, Marion Lindsay was arrested on a warrant for criminal domestic violence. This arrest stemmed from the December 2001 incident where he had beaten Ruby in the restaurant parking lot. Lindsay was released from custody after posting a bond of $1,000. As a condition of his release, the court ordered that he was to have no contact with Ruby. This no contact order was meant to protect Ruby from further violence while the criminal case proceeded. However, like many protection orders, it was simply a piece of paper that relied on Lindsay choosing to obey it. Within 24 hours of his release, Lindsay would violate that order in the most extreme way possible. On September 18, 2002, Ruby Nell Lindsay was trying to get away from her estranged husband and get help from the police. She was staying with her mother at the time, having left the marital home due to the ongoing violence and the separation. That evening, around 8 p.m, Ruby's close friend Celeste Nesbitt gave Ruby a ride home from work. In the car with them were Celeste's 2 young daughters, 4-year-old Keisha and 10-year-old Kira. Keisha was secured in a car seat behind the front passenger seat. Kira sat in the middle of the back seat, and Ruby sat behind the driver's seat. Celeste was driving, and her own mother was in the front passenger seat. The car was a Mercury sedan with dark tinted rear windows. At some point during the drive, Ruby became aware that Marion was following them, or that she was in danger. She made the decision to go to the Inman Police Department, believing that the presence of law enforcement would provide safety. Ruby called 911 while in the car and was speaking with the emergency operator. She was seeking help and trying to reach a place where police could intervene. Celeste drove to the Inman Police Department parking lot, which was located in the small town of Inman in Spartanburg County, South Carolina. They believed that reaching the police station would mean safety for Ruby. However, Marion Lindsay had followed them, or had determined where they were going. When the car arrived at the Inman Police Department parking lot, Lindsay was there as well. He approached the Mercury sedan where Ruby was hiding in the back seat along with the two children. Ruby was still on the phone with the 911 operator at this moment, reporting what was happening. Lindsay was armed with a handgun. He fired his weapon at the car multiple times. Court records state that he fired at least 4 times. The bullets struck Ruby Nell Lindsay as she sat in the back seat. She was shot 3 times in the head. These were fatal wounds delivered at close range into the confined space of the car's interior. The shooting took place despite the presence of 2 young children in the back seat with Ruby. 4-year-old Keisha and 10-year-old Kira were in the car witnessing this violence. They were trapped in the vehicle as Marion Lindsay shot through the windows or door at Ruby. The dark tinted windows meant that Lindsay may not have been able to see exactly where each person was positioned, but he knew that there were multiple people in the car when he fired the weapon repeatedly. The prosecution would later argue that this demonstrated a reckless disregard for human life, as he was willing to fire multiple shots into a car, knowing that children were present. After shooting Ruby, Marion Lindsay's actions in the parking lot drew the attention of an Inman police officer named Harvey Godfrey Jr. Officer Godfrey was present at the police department when the shooting occurred. Different accounts exist about exactly what happened next. According to some sources, Lindsay pointed his gun at Officer Godfrey, who then fired his own weapon at Lindsay. Officer Godfrey shot at Lindsay 4 times, wounding him. Other accounts suggest that after killing Ruby, Lindsay then shot himself in the head in an apparent suicide attempt. It is possible that both things happened, with Lindsay pointing the gun at the officer before turning it on himself. Regardless of the exact sequence, Marion Lindsay sustained a gunshot wound to his head, but survived the injury. Ruby Nell Lindsay died in the parking lot of the Inman Police Department from the 3 gunshot wounds to her head. The place where she had gone seeking protection became the location of her murder. The 911 call that she had made while trying to get help continued through the shooting. The 2 children who witnessed the killing were traumatized by what they had seen. Ruby's family lost a daughter and mother. Her own 2 sons, the children she shared with Marion, lost their mother and faced the reality that their father had killed her. Marion Lindsay was transported to a hospital where he was treated for his gunshot wound to the head. Once he was medically stable, he was taken into police custody and formally charged with murder. The case against him was substantial. There were eyewitnesses to the shooting, including the children in the car and Officer Godfrey. Ruby had been on the phone with the 911 operator during the attack, creating an audio record. The physical evidence at the scene, including the weapon and ballistics, supported the prosecution's case. Most significantly, Lindsay's long-documented history of domestic violence against Ruby provided clear motive and pattern evidence. In October 2002, Marion Lindsay was indicted for murder by a Spartanburg County grand jury. The state prosecutors made the decision to seek the death penalty in this case. They served Lindsay with formal notice that they would be asking a jury to sentence him to death if he was convicted. They also filed notice of the statutory aggravating circumstances they would rely on to justify capital punishment. The aggravating factor they cited was that Lindsay's act of murder knowingly created a great risk of death to more than one person in a public place by means of a weapon which normally would be hazardous to the lives of more than one person. This referred to the fact that he had fired multiple shots into a car where he knew children were present, in the parking lot of a police department. The trial took place in 2004 before Circuit Judge John C. Few. The case was divided into 2 phases, as is standard in death penalty prosecutions. The first phase, known as the guilt phase, required the jury to determine whether Marion Lindsay was guilty of murder. The second phase, known as the penalty phase, would only occur if the jury found him guilty and would determine whether he should be sentenced to death or to life in prison without possibility of parole. During the guilt phase of the trial, the prosecution presented their evidence systematically. Celeste Nesbitt testified as the state's main witness. She described what happened on the evening of September 18, 2002, when she drove Ruby home from work. She explained how they went to the police department parking lot and what occurred when Marion Lindsay arrived and shot Ruby while she sat in the back seat with Celeste's daughter. The testimony from Celeste established the basic facts of the killing and provided eyewitness corroboration of the events. The prosecution also presented evidence of Lindsay's long history of domestic violence against Ruby. They called witnesses who had seen him strike Ruby on multiple occasions during their marriage. They introduced records of the domestic violence incidents from 1996, 1999, 2000, and 2001. They presented evidence of the December 2001 restaurant parking lot beating and the arrest warrant that resulted from it. They showed that Lindsay had been arrested on September 17, 2002, just 1 day before the murder, and had been released on bond with a no-contact order that he immediately violated by tracking down and killing Ruby the next day. This evidence painted a picture of a man with a pattern of violence toward his wife, who escalated to murder when she tried to permanently leave the relationship. Marion Lindsay did not dispute that he had shot and killed Ruby. His defense strategy centered on trying to reduce the charge from murder to manslaughter by arguing that he lacked the malice required for a murder conviction. The defense theory was that Lindsay had been depressed because Ruby was keeping him from seeing their 2 sons. They claimed she had denied him access to his children, blocked his phone calls, and refused to talk to him. The defense argued that when Ruby refused to speak with him in the car in the parking lot, his rage boiled over and he snapped, killing her without the premeditation or malice aforethought that defines murder. They portrayed the killing as a crime of passion, driven by emotional distress over being separated from his children, rather than a calculated murder. The jury did not accept the defense theory. After hearing all the evidence and arguments during the guilt phase, they deliberated for less than 15 minutes on Friday afternoon before returning a guilty verdict on the charge of first-degree murder. The extremely short deliberation time indicated that the jury found the evidence of Lindsay's guilt to be overwhelming and saw no merit in the manslaughter argument. The prosecution had successfully established that Lindsay had acted with malice when he tracked down Ruby, followed her to the police station, and shot her multiple times in the head while she sat in a car with young children present. Solicitor Trey Gowdy, who prosecuted the case, spoke emotionally about the verdict. He told reporters that he hoped the verdict would help Ruby's family heal from what he called a horrific tragedy. He emphasized that Ruby had done everything she could to get away from an abusive relationship, but it was not enough. He made clear that the system had failed to protect her despite her efforts to escape. Gowdy also stated that there was no question Marion Lindsay had malice in his heart on the day of the murder. He told the jury that malice was demonstrated by the fact that Lindsay fired a gun into a car with 2 children inside it, showing a complete disregard for innocent life. After the guilty verdict, the trial moved into the penalty phase, where the jury would decide whether Marion Lindsay should be sentenced to death or to life in prison without parole. During this phase, both sides presented additional evidence specifically relevant to the sentencing decision. The prosecution presented aggravating factors, which are circumstances that make the crime particularly heinous and support imposing a death sentence. The defense presented mitigating factors, which are circumstances that might call for mercy or suggest a lesser sentence is more appropriate. The prosecution's case in the penalty phase focused heavily on the pattern of domestic violence and the particularly egregious circumstances of the murder. They presented evidence that Lindsay had beaten Ruby in front of others on multiple occasions throughout their relationship. They detailed his criminal history, which included not only the domestic violence arrests, but also charges for assault and battery with intent to kill, and trafficking crack cocaine. This evidence showed that Lindsay had engaged in serious criminal activity beyond the domestic violence. The prosecution emphasized that Ruby had been on the phone with 911, trying to get help when she was killed. They highlighted that the murder took place in the parking lot of a police department, where Ruby had gone specifically seeking protection. They stressed that 2 young children were traumatized by witnessing the killing. The prosecution painted Marion Lindsay as a dangerous, violent man who had murdered his wife in cold blood despite her desperate attempts to escape him and find safety. The defense presented mitigating evidence in an attempt to spare Lindsay from execution. They called psychologists and other expert witnesses who had evaluated Lindsay after his arrest. Brawley, a psychologist, testified that Lindsay had been evaluated at the William S. Hall Psychiatric Institute, a facility operated by the South Carolina Department of Mental Health. Testing at this facility showed that Lindsay had an IQ of 76, which fell in the range of borderline intellectual functioning. When he was retested, his IQ measured in the 80s. Dr. Brawley recommended that Lindsay be evaluated by a behavioral neurologist because of abnormalities that appeared in his psychological testing. He was subsequently seen by Dr. Absher, a behavioral neurologist, who reported that Lindsay had a normal neurological exam. However, Dr. Malikian testified that neuropsychological testing showed Lindsay had some abnormalities related to naming ability, copying designs, dexterity, and fine motor skills. The defense also presented evidence about Lindsay's troubled background and mental health history. Psychologists testified that Lindsay had told them about a suicide attempt when he was 12 years old. According to his self-report, he was hospitalized for over a month after this childhood suicide attempt. He also reported that he had tried to kill himself in 2001 and again in August 2002, just weeks before he murdered Ruby. The defense presented this history of depression and suicidal thinking as evidence that Lindsay was mentally unwell and suffering from untreated mental illness. They argued that his background and psychological issues should be considered as mitigating factors that explained, though did not excuse, his actions. A social worker named Jan Vogelsang testified for the defense during the penalty phase. She had conducted what is known as a biopsychosocial assessment of Lindsay and his family. This type of assessment involves gathering extensive information about a person's background, family history, and life circumstances to try to understand how they came to be in their current situation. Vogelsang testified that Lindsay had grown up in what she described as abject poverty. She stated that his family had a history of multiple dysfunctions, including sexually inappropriate behaviour, abandonment and desertion of children, drug dealing, domestic and non-domestic violence, imprisonment, untreated mental illnesses, suicide attempts, lack of education, and belief in folk practices. The defence used this testimony to argue that Lindsay's upbringing in this extremely dysfunctional environment had damaged him psychologically and contributed to his inability to cope with stress in healthy ways. The defence attorneys argued that even though Lindsay's issues did not excuse the murder, his background helped explain how he could end up committing such a crime. They emphasised that Lindsay had been depressed and suicidal during his separation from Ruby. They noted that he had lost weight and was clearly struggling emotionally. They pointed to Dr. Malikian's testimony about Lindsay's state of mind and argued that all of his frustration, depression, and sense of loss regarding his children had come together at the time of the murder. The defence also highlighted that Lindsay had attempted to commit suicide by shooting himself in the head while still in the parking lot after killing Ruby, suggesting that he immediately regretted what he had done and wanted to die. In their closing arguments during the penalty phase, the defence asked the jury to sentence Lindsay to life in prison rather than death. They argued that this would allow him to continue being a father to his two sons, who had already lost their mother and should not lose their father as well. This argument was somewhat problematic given that Lindsay was the person who had deprived his sons of their mother in the first place, but the defence was making any argument they could to avoid the death penalty. They asked the jury to show mercy based on Lindsay's low IQ, his troubled background, his untreated mental illness, and his depression. The jury deliberated on the sentence and weighed the aggravating factors against the mitigating factors. The statutory aggravating circumstance was that Lindsay had knowingly created a great risk of death to more than one person in a public place by firing a gun multiple times into a car where he knew children were present. The jury could also consider the extreme violence of the crime, the vulnerability of Ruby as a domestic violence victim who was trying to escape, the fact that she was killed while seeking police protection, and the trauma inflicted on the child. Witnesses. When they weighed these aggravating factors against the mitigating factors of Lindsay's background, mental health issues, and low IQ, the jury concluded that death was the appropriate sentence. After deliberating for approximately 3.5 hours, the jury of 9 men and 3 women recommended that Marion Alexander Lindsay be sentenced to death for the murder of Ruby Nell Lindsay. In South Carolina's death penalty system at that time, the jury's recommendation was not binding, but carried significant weight. Circuit Judge John C. Few reviewed the jury's recommendation and the evidence from both phases of the trial. Judge Few agreed with the jury's assessment and formally imposed the death sentence. He found that the aggravating circumstances outweighed the mitigating circumstances and that death was the appropriate punishment for this crime. Judge Few set a tentative execution date of July 26, 2004. However, Marion Lindsay would not be executed in 2004 or in the 2 decades that followed. Like all death sentences, his case would go through multiple levels of appeals. Lindsay's conviction and death sentence were automatically reviewed by the South Carolina Supreme Court, as required by state law for all capital cases. In 2007, the South Carolina Supreme Court issued a decision affirming both the conviction and the death sentence. The court found that the trial had been conducted properly, that the evidence supported the guilty verdict, and that the death sentence was proportional to the crime. Marion Lindsay then petitioned the United States Supreme Court to review his case, but the Supreme Court denied his petition in 2007, declining to hear the case. After his direct appeals were exhausted, Lindsay filed for post-conviction relief in 2007. This is a separate legal process where a convicted person can raise issues that were not addressed in the direct appeals, such as claims that their trial attorneys provided ineffective assistance or that new evidence has come to light. Lindsay's post-conviction relief petition raised multiple arguments about why he deserved a new trial or a new sentencing hearing. A hearing on his petition was held in 2010. At this hearing, Lindsay's new attorneys called witnesses and presented evidence attempting to show that his trial defence had been inadequate. One of Lindsay's main arguments in his post-conviction relief case was that his trial attorneys had not properly investigated his background and mental health issues before the penalty phase. He claimed that if his lawyers had done a more thorough investigation, they could have presented more compelling mitigating evidence that might have persuaded the jury to spare his life. His post-conviction attorneys brought in additional experts who had conducted more extensive evaluations of Lindsay's childhood, family history, and mental health. These experts testified about the severity of the dysfunction and poverty in Lindsay's upbringing. However, the post-conviction court found that Lindsay's trial attorneys had presented sufficient mitigating evidence and that any additional evidence likely would not have changed the outcome. Lindsay also argued that his trial attorneys should have called an emergency medical technician to testify during the penalty phase. According to Lindsay, this EMT had treated him at the scene after he was shot, and Lindsay had told the EMT to let him die. Lindsay's lawyers argued that this evidence would have shown remorse and suicidal intent that supported the defence theory. The post-conviction court did not find that excluding this testimony constituted ineffective assistance of counsel. In 2010, the Spartanburg County judge who heard Lindsay's post-conviction relief petition denied his request for a new trial. The judge issued an order dismissing Lindsay's application with prejudice, meaning it could not be filed again. Lindsay appealed this decision to the South Carolina Supreme Court. In 2014, the Supreme Court reviewed the case and ordered the trial judge to reconsider certain aspects of the post-conviction petition. However, when the judge reconsidered the case, he again denied relief. The judge issued an order that was virtually identical to his original 2010 order, with only minor changes to correct typographical and grammatical errors. Lindsay appealed again, arguing that the trial judge had violated the Supreme Court's order by simply reissuing the same decision, rather than conducting a genuine reconsideration. He also continued to argue that his trial defense had been inadequate. The case went back to the South Carolina Supreme Court, which issued a decision in November 2025. The majority of the justices ruled that the trial judge had not violated their 2014 order, and that Lindsay's trial defense had been adequate under the law. However, two justices wrote opinions disagreeing with part of the majority's reasoning. Justice Garrison Hill wrote a separate opinion in which he agreed with the overall result, but dissented from the majority's conclusion that Lindsay's trial counsel had sufficient time to prepare. Justice Hill noted that Lindsay's lawyer was still desperately trying to gather basic records about Lindsay's life after the trial had already begun. Hill wrote that any competent attorney would know that obtaining medical, school, and other protected records can be a difficult and time-consuming process, and that waiting until a few weeks before trial to begin this process was not just objectively unreasonable, but reckless. Justice Donald Beatty agreed with Hill's concerns about the inadequate preparation time. Despite these concerns from two justices, the majority opinion meant that Lindsay's post-conviction relief was denied and his death sentence remained in place. As of the most recent court records, Marion Alexander Lindsay remains on death row in South Carolina. He is currently housed at Broad River Correctional Institution in Columbia, South Carolina. He has been on death row for more than 20 years since his 2004 conviction. The extremely long time he has spent awaiting execution is not unusual for death row inmates, as the appeals process in capital cases typically takes many years or even decades. Lindsay's case has gone through multiple levels of state and federal courts, and additional appeals may still be pending or may be filed in the future. The murder of Ruby Nell Lindsay represents a failure of the systems meant to protect domestic violence victims. Ruby had made multiple reports to police over the years about Marion's violence. She had separated from him. She had gone to stay with her mother. On the day of her death, she went to a police department specifically seeking protection. She was on the phone with 911, asking for help. Despite all of these efforts to escape and get help from the authorities, Marion Lindsay was still able to track her down and kill her. The fact that he could commit this murder in the parking lot of a police station while Ruby was actively calling for help, demonstrates how difficult it can be to protect domestic violence victims from determined abusers. The impact on the children who witnessed the murder cannot be overstated. 4-year-old Keisha and 10-year-old Kira were in the back seat of the car with Ruby when Marion Lindsay shot her 3 times in the head. These young girls experienced severe trauma that will affect them for the rest of their lives. They lost their innocence and their sense of safety in an instant. Ruby's own 2 sons lost their mother and had to grow up knowing their father had killed her. The ripple effects of domestic violence and murder extend far beyond the immediate victim to traumatize children and destroy families. Marion Lindsay's case serves as an example of how domestic violence can escalate to homicide when victims attempt to leave their abusers. Research on domestic violence shows that the most dangerous time for a victim is often when they try to end the relationship. Abusers may become more violent when they feel they are losing control over their victim. Ruby's decision to separate from Marion and deny him access to their children triggered his rage and led directly to her murder. The warning signs were all present in their history, including the multiple documented incidents of violence, the escalating severity of the attacks, and Marion's inability to accept that the relationship was over. The death sentence imposed on Marion Lindsay reflected the jury's and judge's assessment that his crime was among the most serious murders under South Carolina law. The aggravating circumstances included the creation of a great risk to multiple people, including children, the murder occurring in a public place, the use of a deadly weapon, and the murder of a domestic violence victim who was actively seeking police protection. While Lindsay's defenders pointed to his troubled background and mental health issues as reasons for mercy, the jury and judge concluded that these mitigating factors did not outweigh the severity of what he had done to Ruby. More than 2 decades after Ruby Nell Lindsay's death, her case remains a tragic reminder of the deadly consequences of domestic violence and the challenges of protecting victims, even when they do everything they can to escape. Marion Lindsay sits on death row, having spent over 20 years in prison, awaiting an execution that may or may not ever occur. Ruby's family and the children who witnessed her murder carry the trauma of that September day in 2002. The case demonstrates the urgent need for better systems to prevent domestic violence homicides and protect victims before it is too late to save them. Before we move on, make sure to subscribe if you're enjoying this breakdown. Moving on to case number 2. Case number 2. Chad Daybell was a man from Idaho who was convicted of murdering his first wife, Tammy Daybell, and 2 children who belonged to his second wife, Lori Vallow Daybell. In 2024, a jury found him guilty of 3 counts of first-degree murder and sentenced him to death. The case became one of the most widely publicized criminal trials in recent years due to the extreme nature of the crimes, the involvement of apocalyptic religious beliefs, and the discovery of the buried remains of 2 children on Daybell's property. The murders were committed in 2019, and investigators spent years building the case that would eventually lead to Daybell receiving a death sentence. Chad Daybell was a self-published author who wrote fiction books with doomsday themes and apocalyptic content. He promoted unusual spiritual beliefs, including ideas about the end times, prophecies, and concepts involving people being possessed by evil spirits or dark energy. Daybell wrote books that appealed to readers interested in these fringe religious topics. He was married to Tamara Daybell, known as Tammy, for 28 years before her death. They had 5 children together. The family lived in Salem, Idaho, which is a small community in Fremont County. Tammy worked as a librarian and educator at Central Elementary School. By all accounts from friends and co-workers, Tammy was healthy, active, and had no serious medical problems before her sudden death. Lori Vallow had been married multiple times before meeting Chad Daybell. She had children from previous relationships. Tylee Ryan was her daughter from her 3rd marriage, and Joshua Jackson Vallow, called JJ, was the nephew of her 4th husband Charles Vallow, whom they had adopted. JJ was 7 years old and had special needs that required extra time and attention. Tylee was 16 years old and approaching 17 at the time of her death. Charles Vallow, Lori's 4th husband, learned about her affair with Chad Daybell in 2019. According to police documents, Charles discovered the infidelity 12 days before his death and had threatened to tell Tammy Daybell about the relationship. Charles Vallow was shot and killed by Lori's brother Alex Cox in July 2019. The shooting was initially treated as self-defense. Their prosecutors later alleged it was part of a murder conspiracy. Chad Daybell and Lori Vallow met in late 2018 at a conference related to their shared interest in doomsday religious beliefs. They quickly formed a romantic relationship despite both being married to other people at the time. According to testimony from Melanie Gibb, a friend and confidant of Laurie's, the pair told her they believed they had been married in a previous life. They spoke about being joined for eternity and leading 144,000 people in the end times, referencing imagery from the Book of Revelation in the Bible. Gibb testified that Chad and Laurie shared beliefs about people being overtaken by dark, evil energy. They apparently believed they could identify who was possessed by these dark spirits, and they used terms like zombies to describe people they thought were taken over by evil. Prosecutors argued that Chad and Laurie wanted to be together without the obstacles presented by their existing spouses and Laurie's children. Text messages between them showed they were planning a future together and discussing what needed to happen for that future to become reality. In one message exchange about a month after Charles Vallow's death, Laurie asked Chad if he thought there was a perfectly orchestrated plan to take the children. Chad responded that there was a plan being orchestrated for the children, and that he had been shown the previous night how it all fit together. These messages suggested that both Chad and Laurie were actively planning the murders of the children, rather than the deaths being impulsive acts. Tylee Ryan and JJ Vallow were last seen alive in September 2019. The family had moved from Chandler, Arizona to Rexburg, Idaho that same month. On September 8, 2019, Tylee was photographed with JJ and Alex Cox at Yellowstone National Park. This photo would become important evidence, as it established the last confirmed sighting of Tylee alive. FBI investigation of Alex Cox's cell phone location data showed that after the Yellowstone trip, Cox's phone travelled between Rexburg, where he and Laurie had apartments, and Salem, where Chad Daybell's property was located. On the date when Tylee was last seen, Cox's phone location data placed him in the area of Chad Daybell's backyard, near where Tylee's remains would eventually be discovered buried. JJ Vallow was last reported seen in late September 2019. A witness testified to seeing Alex Cox carrying JJ in his arms around this time. After these September sightings, both children disappeared completely. Family members who tried to reach them were given various explanations by Laurie about where the children were. She told different people different stories about their whereabouts. When questioned, she claimed they were with relatives or friends, but these claims were false. The children were never seen alive again after September 2019. On October 9, 2019, just weeks after the children disappeared, an incident occurred involving Tammy Daybell. She reported to police that someone wearing a mask had confronted her in her driveway and had pointed a gun at her, or possibly fired a paintball gun. Tammy was frightened by this encounter. Cell phone data later showed that Alex Cox's phone was in the area near the Daybell residence at the time of this incident. Prosecutors argued that this was an initial attempt to kill Tammy that failed, and that Cox was the person who had confronted her. Tammy survived this incident, but it would not be long before another attempt was made on her life. On the night of October 18, 2019, Alex Cox's cell phone location placed him at a church building near the Daybell residence around 10 p.m. His phone then travelled to a hotel near Idaho Falls. The next morning, October 19, 2019, Tammy Daybell was found dead in the bedroom she shared with Chad at their home in Salem, Idaho. Chad called 911 to report that his wife had died. When first responders arrived, they found Tammy's body in the bed covered with a blanket. Chad told them he had found her deceased that morning after waking up. When Fremont County Coroner Brenda Dye arrived at the scene, Chad Daybell was described by various responders as being distraught and crying. Dye observed that Tammy's body was very cold, indicating she had been dead for several hours, not just minutes. There was pink foam coming from Tammy's mouth, which Dye noted as blood-tinged sputum. Tammy's body showed signs of rigor mortis and lividity, which is the pooling of blood in the body after death that shows what position someone was in when they died. The lividity pattern indicated Tammy had died lying on her back. Chad told Coroner Dye several things about the circumstances of Tammy's death. He said that Tammy had been feeling unwell lately and had episodes of fainting. He mentioned an incident at their church temple where she had fainted when she stood up. He claimed she had been having shaking fits and possibly convulsions or seizures. He said that during the night, Tammy had been coughing and had gotten up and vomited, and he had helped her back to bed. He stated that he woke up in the morning because he felt Tammy roll off the bed, pulling the blankets off of him, and that is when he realised she was dead. Coroner Dye found Chad's explanation suspicious for several reasons. She asked him how Tammy's deceased body could have rolled out of bed if she was already dead, since dead bodies cannot move on their own. She questioned how Tammy's legs were still wrapped in the covers if she had rolled out. Chad told her he must have pulled on the sheet himself, releasing Tammy's body. None of this made sense to Dye given the coldness of the body and the evidence at the scene. She also observed what appeared to be old bruises on Tammy's body at the time, though she did not initially suspect foul play. At that time, no autopsy was performed on Tammy Daybell. The coroner initially attributed her death to natural causes, likely a heart attack. Chad Daybell actively discouraged having an autopsy done. Stephen Schultz, a funeral director and former neighbour who came to transport Tammy's body to Utah for the funeral, testified that he suggested an autopsy might be useful for Chad's children to know if there were any hereditary medical conditions, since Tammy was only 49 years old, and it was unusual for someone that young to die suddenly. Chad declined this suggestion. Tammy's daughter Emma also reportedly did not want an autopsy performed. Chad told Schultz and others that he wanted to hold the funeral as quickly as possible and did not want to drag things out. Tammy was buried in Springville, Utah 3 days after her death on October 22, 2019. Friends and co-workers of Tammy Daybell testified that they were shocked by her death because she had appeared healthy. Multiple women testified that they had attended exercise classes with Tammy in the months before she died. Kelsey Harris taught a cardio clogging class that met once a week, and Tammy had been a regular student. Harris said Tammy was fit and kept up with the 60-minute high-intensity class without difficulty. Shanna Miller and Jennifer Geisler both worked at Central Elementary School with Tammy and had attended a high-intensity fitness class with her and her daughter for at least 4 months before her death. They described Tammy as being in good health and physically active. Shanna Miller testified that she had seen Tammy the day before her death and that Tammy appeared happy and jovial. None of these women had heard Tammy express concerns about her health or mention seizures, fainting spells, or other medical problems that Chad had described to the coroner. Just 2 weeks after Tammy Daybell's death, on November 5, 2019, Chad Daybell married Lori Vallow in Hawaii. This quick remarriage raised immediate suspicions among Tammy's family members. Tammy's sister Samantha Gwilliam testified that the family learned about the remarriage and was shocked. Chad had told them he was marrying a woman named Lori Ryan, whose previous husband had died of a heart attack. When Samantha asked if Lori had children, Chad told her no, and that they would be empty nesters. This was a lie, as Lori had children including Tylee and JJ, though they were already dead at this point. Chad and Lori had purchased their wedding rings while Tammy was still alive, indicating they had been planning their marriage before Tammy's death. In late November 2019, family members of JJ Vallow contacted police because they had not been able to reach the boy and were concerned about his welfare. JJ's grandparents, Kay and Larry Woodcock, reported him missing. This triggered a welfare check and investigation by law enforcement. When police tried to locate JJ and question Lori about his whereabouts, she gave evasive and false answers. She claimed JJ was staying with relatives in Arizona. When police checked with these relatives, they confirmed JJ was not with them and they had not seen him. Investigators quickly realized that both JJ and his older sister Tylee were missing and that no one had seen either child in months. A multi-state search was launched to try to find the missing children. Chad and Lori were located in Hawaii, where they were living together after their marriage. In February 2020, they were arrested during their honeymoon for child abandonment and other charges related to the missing children. However, the children's bodies had not yet been discovered, and murder charges could not be filed at that time. The investigation continued as law enforcement worked to determine what had happened to Tylee and JJ. As the investigation progressed, police in Arizona contacted Fremont County Coroner Brenda Dye, inquiring about Tammy Daybell's death and requesting her coroner records. The Arizona investigators mentioned that there had been a death in Arizona, where Chad's name had been brought up, referring to Charles Vallow's shooting. They also mentioned an attempted murder, which was a shooting incident involving Brandon Boudreaux, Lori's former nephew-in-law, who was shot at in Arizona. When Coroner Dye heard all these names connected to an investigation involving Chad Daybell, her mind changed about the circumstances of Tammy's death. She began to suspect that Tammy might have been murdered rather than dying of natural causes. In December 2019, approximately 2 months after Tammy was buried, her body was exhumed from the grave in Utah so that an autopsy could be performed. Dr. Eric Christensen, who was Utah's chief medical examiner at the time, and Dr. Lily Marsden conducted the autopsy. What they found contradicted the initial natural causes determination. The autopsy revealed bruises on Tammy's arms and chest that had not been clearly identified at the original death scene. Under microscopic examination, these bruises showed only bleeding into the soft tissues under the skin, with no evidence that the body had begun to mount a response to heal the injuries. This indicated the bruises were acute, meaning they had occurred within a couple of hours before Tammy's death, or possibly a few minutes after death. These were peri-mortem bruises, occurring around the time of death. Dr. Marsden testified that the bruising pattern could indicate that 1 or 2 people were present when Tammy was killed. The location and nature of the bruises suggested someone may have restrained her. The autopsy found no other clear cause of death. Tammy's heart was normal and healthy. There was no evidence of seizures or the medical conditions that Chad had described to the coroner. When an autopsy comes back negative with no apparent cause of death, medical examiners consider 3 main possibilities: seizures, heart failure, and asphyxia. Since Tammy's heart was normal and there was no visible cause for sudden onset seizures like a brain tumour, asphyxia became the most likely explanation. Asphyxia is what happens when the body is deprived of oxygen, resulting in unconsciousness and death. The medical examiners concluded that Tammy Daybell died from asphyxiation by suffocation. Dr. Marsden explained that suffocation through smothering, such as placing a bag over the head or putting weight on the chest to prevent breathing, would not necessarily leave outward signs on the body that investigators could easily find. However, the acute bruising and the exclusion of other causes of death led them to determine that another person restricting Tammy's airway had caused her death. The manner of death was officially changed from natural causes to homicide. Coroner Dye testified that one of the factors that influenced her to support the homicide ruling was the presence of the pink foam in Tammy's lungs that was still there 2 months later when the body was exhumed. She stated there should not have been foam still in the lungs after that amount of time, which was suspicious. The date Alex Cox died is significant to the investigation. Cox died on December 12, 2019, which was the day after Tammy Daybell's body was exhumed for autopsy. Authorities stated that Cox died from natural causes and he was never charged with any crimes related to the murders. However, testimony at trial revealed that the night before Cox died, he told his wife that he hoped he was not going to be their fall guy. This statement suggested Cox knew he was involved in criminal activity with Chad and Lori, and feared he would take the blame for everything. His sudden death from natural causes meant he could never testify about his involvement or what he knew about the murders. On June 9, 2020, law enforcement executed a search warrant on Chad Daybell's property in Salem, Idaho. During the search, they made the grim discovery of human remains buried on the property. The bodies of both Tylee Ryan and JJ Vallow were found. The remains were in different locations on the property. JJ's body had been wrapped in plastic trash bags and duct tape. He was found in a shallow grave. Tylee's remains were in much worse condition, described as a mass of tissue and bone. Her DNA was later found on a pickaxe and shovel that were in a shed on the property, suggesting these tools had been used in connection with her burial or dismemberment. The discovery of the children's bodies on Chad Daybell's property provided the evidence needed for murder charges to be filed. Chad Daybell and Lori Vallow Daybell were both indicted on murder charges in May 2021, nearly 2 years after the children died. They were charged with first-degree murder and conspiracy to commit first-degree murder in the deaths of Tylee Ryan, JJ Vallow, and Tammy Daybell. Chad was also charged with 2 counts of insurance fraud because he had been the beneficiary of life insurance policies on Tammy, totaling $430,000. Prosecutors alleged that Chad had maxed out Tammy's life insurance coverage the month before she died, showing premeditation for her murder. The cases of Chad and Lori were initially joined together, but were later separated at Chad's request, so they would be tried individually. Lori Vallow Daybell's trial took place first, beginning in April 2023. During her trial, prosecutors presented the theory that Lori and Chad had become obsessed with doomsday religious beliefs, and used these beliefs to justify murdering people who stood in the way of their relationship and their financial goals. The prosecution argued that Lori used money, power, and sex, or the promise of these things, to get what she wanted. Her children were obstacles to the life she wanted with Chad. JJ required time, effort, and energy due to his special needs, which took away from the time Lori wanted to spend with Chad. Tylee was receiving Social Security benefits from her deceased father, and prosecutors argued that Lori wanted that money. With both children dead Laurie could collect their benefits while not having to care for them, and she was free to pursue her relationship with Chad without interruption. The jury in Laurie's trial found her guilty of murdering her 2 children and conspiring to murder Tammy Daybell. She was sentenced to multiple life sentences in prison without the possibility of parole on July 31, 2023. The death penalty was taken off the table in Laurie's case because a judge granted a defense motion to dismiss it, finding there had been insufficient review of evidence related to capital punishment. Laurie has appealed her convictions to the state Supreme Court, with her legal team raising the issue of whether she was mentally competent to stand trial. She also faces additional charges in Arizona related to the death of her 4th husband, Charles Vallow, and the attempted murder of Brandon Boudreaux. Chad Daybell's trial began on April 1, 2024, with jury selection. The trial was held in Ada County at the courthouse in Boise, Idaho. The proceedings lasted nearly 2 months. Prosecutors Lindsay Blake and Rob Wood, along with their team, presented extensive evidence against Chad. They had the benefit of having already prosecuted Laurie's case the previous year, so they were well prepared and familiar with the evidence and witnesses. The prosecution team worked with numerous law enforcement agencies from different states, including Idaho, Arizona, Utah, and federal investigators. The complexity of the case required coordination between Rexburg Police Department, Fremont County Sheriff's Office, FBI, and other agencies. All of this investigative work came together to build the case against Chad Daybell. During Chad's trial, the prosecution presented evidence showing his involvement in all 3 murders. They showed the text message exchanges between Chad and Laurie, where they discussed plans for the children. They presented cell phone location data, showing Alex Cox's movements on the dates when Tylee and JJ disappeared and when Tammy was killed, demonstrating that Cox was near the Daybell property at crucial times. They showed that the children's bodies were found buried on Chad's property, indicating he either killed them himself or was directly involved in burying them. They presented financial evidence showing Chad had increased Tammy's life insurance and quickly collected the payouts after her death. They presented testimony from the medical examiners, explaining how Tammy died from asphyxiation and that her death was a homicide. They showed that Chad had been having an affair with Laurie, had married her just 2 weeks after Tammy's funeral, and had lied to Tammy's family about multiple things, including Laurie having children. Prosecutors argued that Chad Daybell influenced the coroner's initial ruling that Tammy died of natural causes by fabricating details about her medical condition. He had told the coroner about fainting spells, seizures, and convulsions that Tammy allegedly experienced, but none of her friends, family, or co-workers had ever witnessed these problems or heard Tammy mention them. Medical records did not support these claims. Prosecutors contended that Chad lied about Tammy's health to explain away her sudden death and prevent an autopsy that would have revealed she had been murdered. The prosecution painted a picture of Chad as a man motivated by sex, money, and power. They argued that Chad was manipulated by Laurie through sex and the promise of a relationship with her. From the minute he met Laurie, he wanted to be with her, and she knew it. Text messages showed Chad telling Laurie that being with her was the only thing that mattered to him. When prosecutors asked what needed to change for Chad and Laurie to be together, the answer was clear. Tammy was in the way. Once Tammy was eliminated, Chad collected the life insurance money and married Laurie. The children were also in the way of the lifestyle Chad and Laurie wanted, so they were eliminated as well. Chad Daybell's defense attorney, John Pryor, attempted to create reasonable doubt about Chad's involvement in the murders. Pryor argued that there was not enough evidence to tie Chad directly to the killings. He suggested that Alex Cox was the actual culprit who committed the murders, pointing out that Cox's phone data placed him at relevant locations and that Cox died before he could be charged or testify. This defense strategy tried to shift blame entirely onto a dead man who could not defend himself or confirm what had happened. During the sentencing phase of the trial, Pryor tried a different approach. He portrayed Chad as a quiet, reserved, shy young man who grew up in Springville, Utah, a small, tight-knit town of faith. Pryor emphasized that Chad had been married to Tammy for 29 years, and they had raised 5 wonderful children together, while being very deep in their faith and commitment to family. Pryor argued that Chad's life changed in late 2018 when he met Laurie Vallow, who had already been married multiple times. Pryor told the jury that everything that glitters is not gold, and that Laurie glittered but was not gold. He described her as a bomb that was dropped on the life of a small-town boy from Springville, changing the trajectory of what had been an otherwise wholesome life. Pryor argued that chaos hit when Laurie came into Chad's life, and everything became very complicated. He asked the jury to judge Chad based on his life before meeting Laurie, rather than what happened after. However, this defense strategy had a significant weakness. Chad Daybell declined to present any mitigating evidence during the sentencing hearing. Mitigating evidence is information about a defendant's background, mental health, character, or other factors that might encourage jurors to have sympathy and conclude that a life sentence would be more appropriate than death. Chad's defense team apparently had little to offer in this regard. Chad also declined to testify in his own defense during the guilt phase of the trial. He declined to address the court during the sentencing phase when given the opportunity. He remained silent throughout, never expressing remorse or explaining his actions. Jurors later commented that Chad never shed a tear during the trial, even when viewing autopsy photos of the victims, including his own wife lying dead. On May 30th, 2024, after hearing all the evidence and closing arguments, the jury began their deliberations. They deliberated for less than 6 hours before reaching a verdict. The relatively quick deliberation suggested the jury found the evidence of guilt overwhelming. The jury found Chad Daybell guilty on all counts. He was convicted of 3 counts of first-degree murder for the deaths of Tammy Daybell, Tylee Ryan, and JJ Vallow. He was also convicted of 3 counts of conspiracy to commit first-degree murder for each victim. Additionally, he was found guilty of 2 counts of insurance fraud related to collecting Tammy's life insurance benefits. The unanimous guilty verdicts on the first-degree murder charges made Chad eligible for the death penalty under Idaho law. The trial immediately moved into the penalty phase, where the jury would decide Chad's sentence. In Idaho death penalty cases, the jury must determine whether aggravating circumstances exist that justify capital punishment, and whether those aggravating circumstances outweigh any mitigating circumstances. The prosecution had the burden of proving aggravating factors beyond a reasonable doubt. They argued that the murders were especially heinous, atrocious, or cruel, manifesting exceptional depravity. They argued that Chad exhibited utter disregard for human life. They contended that Chad's conduct before, during, and after the murders showed he had a propensity to commit murder and would constitute a continuing threat to society. On Friday, May 31st, 2024, family members of the victims gave emotional impact statements to the jury. Tammy Daybell's father, Ron Douglas, told the jurors that the case had left him angry. He said it destroyed him to know that Tammy was treated the way she was. He expressed comfort that Tammy was resting peacefully in Utah, buried alone near her beloved mother. Tammy's brother, Matthew Douglas, spoke about how Tammy had been the heart and glue of the siblings, and how her loss had affected the family. Another brother, Benjamin Douglas, talked about how his children only know their Aunt Tammy through pictures, stories, and a grave marker that they frequently request to visit. Kay Woodcock, JJ's grandmother, spoke about the immense pain that she and everyone in her family continues to endure daily. She described trying to explain a pain that cannot be put into words. She talked about how there have been too many situations in the past few years where her family was slammed with the fact that JJ will never hit another milestone in his life. She cried as she spoke about JJ being incredibly smart and compassionate. She expressed anguish over not being able to create more memories with him. Kay asked the constant question that haunts the family: who would JJ have become? Would he be a famous scientist with incredible math skills? What would his amazing imagination have bloomed into? Kay described a hole in her heart, and in the hearts of every family member that can never be filled and will remain for the rest of their lives. Larry Woodcock, JJ's grandfather, spoke emotionally about the verdict and the victims. He asked what Chad and Laurie had accomplished through their crimes. His answer was nothing, except destroying families. He emphasized that while the defendants destroyed lives, they could not destroy the memories that relatives have of the victims. Those memories, he said, they cannot take away. Larry described feeling like he could not breathe when he heard the guilty verdict in court, overcome with emotion at finally seeing justice. After hearing the victim impact statements and the arguments from both sides about sentencing, the jury deliberated for approximately a day and a half. The sentencing deliberations took longer than the guilt phase deliberations, as jurors faced the weighty decision of whether Chad Daybell should be executed. The jury had to unanimously agree on the death penalty for it to be imposed. On Saturday, June 1st, 2024, the jury returned with their sentencing decision. They had to complete a lengthy verdict form addressing all the aggravating circumstances for each victim. The jury found that aggravating circumstances existed for all 3 murders. They found that the state had proven beyond a reasonable doubt that the murders were especially heinous, atrocious, or cruel. They found that Chad exhibited utter disregard for human life. They found that Chad's conduct demonstrated a propensity to commit murder, which would probably constitute a continuing threat to society. Having found all these aggravating circumstances, the jury then determined whether the death penalty was justified and appropriate. They unanimously recommended that Chad Daybell be sentenced to death for the 3 murders. Judge Stephen Boyce, who had presided over both Laurie's trial and Chad's trial, formally imposed the sentence. On June 1, 2024, Judge Boyce sentenced Chad Daybell to death for the murders of Tammy Daybell, Tylee Ryan, and JJ Vallow. The judge also sentenced Chad to 15 years in prison on each of the 2 insurance fraud counts, to run concurrently with each other. Chad Daybell showed no emotion as the death sentence was announced. He had a blank expression on his face and remained motionless. He did not make any statement to the court when given the opportunity. Fremont County Prosecutor Lindsay Blake issued a statement after the sentencing, saying that the case had been about speaking for and seeking justice for the lives of 3 wonderful humans whose lives were cut way too short by the selfish desires of Chad Daybell and his co-defendant Laurie Vallow. Blake acknowledged that the case had been challenging, both because of its complexity and because of her personal experience as a new mother during the prosecution, making it difficult to work on a case involving murdered children. She said she could not begin to imagine the family's pain. Blake expressed hope that the verdict would allow the victims' families and friends a chance to heal, and stated that justice had been served for the victims. Madison County Prosecutor Rob Wood, who had taken the lead on the prosecution, issued a statement saying that while nothing can undo the immense harm caused, the prosecution team had worked tirelessly to secure a measure of justice. Wood later spoke to reporters about the case, describing it as unlike any he had prosecuted before. He said at the beginning of the investigation, it was like drinking from a fire hose because of the overwhelming amount of information and the involvement of so many different law enforcement agencies from multiple states. He praised the teamwork and the willingness of people to work together and share information across jurisdictions. Chad Daybell now sits on death row in Idaho, awaiting execution. As of the most recent information, he is housed at a state correctional facility with the other death row inmates in Idaho. Since the death penalty was established in Idaho in 1864, the state has carried out 29 executions, with the most recent execution occurring in 2012. There are currently 8 people on death row in Idaho, according to the State Department of Corrections. Chad's case will go through the automatic appeals process that is standard for all death penalty cases. These appeals can take many years or even decades to complete. It is possible that Chad will spend the rest of his life in prison, awaiting execution that may never occur. Or he may eventually be executed if all his appeals are unsuccessful and the death sentence is carried out. The case drew intense national and international media coverage from the moment the children were reported missing in 2019 through the trials and sentencing in 2024. The unusual elements of the case, including the doomsday religious beliefs, the term zombie children that was used to describe the victims, the discovery of the bodies buried on Chad's property, and the involvement of multiple murders across multiple states, made it a sensational true crime story that captured public attention. A Netflix documentary was made about the case. The extensive publicity meant that potential jurors had likely heard about the case before trial, making jury selection challenging. The Tammy Douglas Daybell Foundation released a statement after the sentencing, thanking everyone who put in countless hours of work to reach that point, including law enforcement, prosecutors, the media, and members of the public who watched and listened to coverage of the case. The foundation was established in Tammy's memory to honour her life and legacy. The deaths of Tammy Daybell, Tylee Ryan, and JJ Vallow represent a tragic intersection of manipulation, greed, twisted religious beliefs, and cold-blooded murder. 3 innocent people lost their lives because 2 people wanted money, freedom, and each other without any obstacles in their way. Tammy was a healthy, active woman who worked as a librarian and educator and had been married for nearly 3 decades. She was murdered in her own bed by suffocation, likely held down by 1 or more people while being unable to breathe. Her husband quickly remarried and collected her life insurance money. Tylee was a 16-year-old girl whose remains were so badly damaged that they were described as a mass of tissue and bone when found. JJ was a 7-year-old boy with special needs who was wrapped in plastic and tape and buried like trash. Both children had their whole lives ahead of them before they were killed and hidden in the ground. Chad Daybell's conviction and death sentence represent the legal system's determination that he deserves the ultimate punishment for these crimes. The jury heard all the evidence, saw the autopsy photos, listened to testimony about how the victims were found, and learned about Chad's lies and manipulation. They concluded unanimously that death was the appropriate sentence. Whether Chad will ultimately be executed or will die of natural causes on death row remains to be seen, but he will spend the rest of his life in prison for the murders of his wife and 2 children who were not even his own, but who died on his property and were buried in his backyard while he went on with his life as though nothing had happened. Before we move on, make sure to subscribe if you're enjoying this breakdown. Moving on to case number 3. Case number 3. Kim Van Pelt was a construction worker from Alabama who was convicted of capital murder and sentenced to death in 2006 for killing his wife, Sandra Marie Osment Van Pelt, just 13 days after they were married. The state of Alabama argued that Van Pelt murdered Sandra to collect on a $300,000 life insurance policy he had taken out on her life shortly after their wedding. The case involved a couple who had met through an internet chat room, a rapid marriage, a quickly purchased insurance policy, and a body found dumped on a rural roadside. The evidence presented at trial suggested Van Pelt had carefully planned and executed the murder, then attempted to cover his tracks by cleaning the crime scene and disposing of Sandra's body. The jury convicted him of capital murder for pecuniary gain and recommended death by a vote of 10-2, which the circuit court judge imposed. Kim Van Pelt was 44 years old at the time of Sandra's death in November 2004. He was a construction worker who lived in Tuscumbia, Alabama, which is located in Colbert County in the northern part of the state. Sandra Marie Osment was 40 years old and originally from Southgate, Michigan. She was a mother of 3 daughters from previous relationships. Sandra worked at a Shoney's restaurant in Muscle Shoals, Alabama. She had relocated to Alabama after meeting Kim through an internet chat room where they had connected and developed a relationship online before meeting in person. The relationship between Kim and Sandra progressed quickly from their initial online contact to marriage. After communicating through the internet chat room and presumably getting to know each other through that medium, they decided to marry. They were wed in November 2004. The marriage took place at a time when online dating and internet relationships were becoming more common, but were still relatively new phenomena that sometimes led to hasty decisions by people who did not know each other well in person. Kim and Sandra's marriage would last only 13 days before Sandra was found dead under circumstances that immediately raised suspicions about her husband's involvement. Just 3 days after marrying Sandra, Kim Van Pelt took out a life insurance policy on his new wife's life. The policy was for $300,000 and named Kim as the beneficiary, meaning he would receive the money if Sandra died while the policy was in effect. This life insurance policy would become a central piece of evidence in the prosecution's case, as they argued it provided the motive for Sandra's murder. Evidence presented at trial showed that when Van Pelt purchased the insurance policy, he was informed by the insurance agent that Sandra's life was conditionally covered pending acceptance of the policy by the insurance company. This conditional coverage meant that if something happened to Sandra before the insurance company fully approved the policy, there might still be a payout, but the coverage was not yet finalised. After purchasing the life insurance policy, Kim Van Pelt made several phone calls to the insurance agent to check on the status of the coverage. The insurance agent, who testified at trial, stated that Van Pelt called multiple times to verify the policies and their status. During one of these conversations, Van Pelt mentioned to the agent that Sandra had previously had cervical cancer, but was now free of cancer. This medical history information was relevant to the insurance application process. The fact that Van Pelt was actively following up on the insurance policy and checking its status suggested to prosecutors that he was very interested in making sure the coverage was in place. The timeline between purchasing the insurance and Sandra's death would prove to be suspicious, as Sandra was killed just days after the conditional insurance approval. On Sunday evening, November 21st, 2004, Kim Van Pelt cooked dinner for Sandra at their mobile home in Tuscumbia. Van Pelt later told police that he had prepared a meal that included sautéed mushrooms. This detail about the mushrooms would become significant because of what the medical examiner would later discover when examining Sandra's body. Van Pelt's statement to police was that Sandra was at home with him on Sunday night and that she left the mobile home on Monday morning, November 22nd, 2004. However, this statement about Sandra leaving Monday morning would prove to be inconsistent with other evidence, particularly the medical examiner's determination of when Sandra actually died. In the early morning hours of Monday, November 22, 2004, 3 different witnesses observed that Sandra's white Pontiac automobile was not parked at the mobile home where she and Kim lived. This was unusual because the car should have been there if Sandra was at home or had just left for work, as a normal morning would suggest. One of these witnesses, a man named Ray McMahon, provided particularly important testimony about what he saw when he drove past the Van Pelt mobile home in the early morning. McMahon testified that he saw Kim Van Pelt's black Chevrolet truck backed up to the front door of the mobile home. He also noticed a rug hanging over the railing of the mobile home. This observation would later take on significance when considered alongside other evidence suggesting that Van Pelt was removing something from the home, potentially Sandra's body, wrapped or contained in that rug. Sandra's body was discovered on Wednesday, November 24, 2004, 2 days after she was last known to be alive. A man named Jerry Evans found Sandra's nude body on the side of County Road 53 near Hamilton, Alabama. Hamilton is located in Marion County, which is adjacent to Colbert County, where the Van Pelts lived. The body had been dumped in a wooded area along the roadside, a location that was removed from the couple's home and appeared chosen to delay discovery of the remains. The fact that Sandra's body was found nude suggested that someone had removed her clothing, though it was not clear whether this was done before or after death. The location where Sandra was found, on a rural road in a neighbouring county, indicated that whoever killed her had transported her body some distance from where she died. Emily Ward, a medical examiner, conducted an autopsy on Sandra's body and testified at trial about her findings. Dr. Ward determined that Sandra died from head injuries and suffocation. This combination of causes of death indicated that Sandra had been subjected to blunt force trauma to her head and had also been prevented from breathing, either through smothering or strangulation or some other means of blocking her airway. The head injuries and suffocation together proved fatal. Dr. Ward also examined the contents of Sandra's stomach during the autopsy. She found undigested food that included mushrooms. Based on the state of digestion and the presence of this undigested food, Dr. Ward testified that Sandra had died within 2 hours of eating a meal that included mushrooms. This testimony about the timing of Sandra's death was crucial because it directly contradicted Kim Van Pelt's statement to police. Van Pelt had told investigators that he cooked dinner with mushrooms for Sandra on Sunday evening and that Sandra was alive on Sunday night and left the mobile home Monday morning. However, the medical evidence showed that Sandra died within 2 hours of eating mushrooms. If Van Pelt cooked mushrooms for Sandra on Sunday evening and she died within 2 hours of eating them, she would have died Sunday night or very early Monday morning, not after leaving the home Monday morning, as Van Pelt claimed. This inconsistency in the timeline was strong circumstantial evidence that Van Pelt was lying about when Sandra died and about her having left the home alive. After Sandra's body was discovered and authorities began investigating her death as a homicide, police obtained permission to search the mobile home where Kim and Sandra Van Pelt had been living. When officers entered the home, they found it to be spotless, exceptionally clean in a way that seemed unusual given the circumstances. The home appeared to have been thoroughly cleaned recently. Roger Morrison, who was the laboratory director of the Huntsville Regional Laboratory for the Alabama Department of Forensic Sciences, assisted in the search. Morrison used a chemical called luminol to test surfaces in the mobile home. Luminol is a forensic tool that causes blood to glow under certain light conditions, allowing investigators to detect blood even when it has been cleaned up or is present in very small amounts. Morrison sprayed luminol in the master bedroom of the mobile home and discovered blood. He explained in his testimony that luminol would detect very diluted blood stains, meaning blood that had been cleaned up or watered down but still left traces behind. The blood that was detected in the master bedroom using luminol was tested and matched Sandra's blood type and DNA. This evidence showed that Sandra had bled in the master bedroom, despite the fact that the room appeared clean to the naked eye. The presence of Sandra's blood in the bedroom, combined with the evidence that the home had been thoroughly cleaned, suggested that Sandra had been killed or seriously injured in that room, and that someone had made significant efforts to clean up the blood afterward. Police also found other items in the mobile home during their search. In a garbage can inside the home, officers discovered a photograph of Sandra and a receipt for cleaning materials. The receipt for cleaning supplies was consistent with the evidence that the home had been recently and thoroughly cleaned, and it suggested that someone had purchased cleaning products specifically for this purpose. Investigators also searched Kim Van Pelt's black Chevrolet truck and other areas associated with him. During the investigation, police used trained cadaver dogs to search both Sandra's white Pontiac automobile and the Van Pelt mobile home. These specially trained canine units can detect the scent of human remains or decomposition. While Van Pelt would later challenge the admission of this evidence on appeal, the searches were conducted as part of the investigation, and the findings were presented to the jury. When Alabama Bureau of Investigation investigator Mark McCormick interviewed Kim Van Pelt provided a statement about the events surrounding Sandra's disappearance. As mentioned earlier, Van Pelt told police that he had cooked dinner for Sandra on Sunday evening, including sautéed mushrooms, and that Sandra was at home Sunday night. He stated that Sandra left the mobile home Monday morning. This account was his explanation for why Sandra was not at the home when people began looking for her. However, this story fell apart when compared to the medical evidence about the time of death and the testimony from witnesses about what they observed at the mobile home. During the investigation and trial, additional evidence emerged about Van Pelt's actions and state of mind around the time of Sandra's death. One particularly damaging piece of testimony came from an inmate who had been jailed with Van Pelt after his arrest. This inmate, Ed Parsons, testified at trial about conversations he had with Van Pelt while they were both in jail. According to Parsons, Van Pelt approached him with a scheme to fabricate a phony confession regarding the murder. Van Pelt allegedly asked Parsons to participate in creating this false confession, with the plan being that someone else would confess to killing Sandra, which would exonerate Van Pelt. Parsons testified that Van Pelt promised to share proceeds from a $100 million malicious prosecution lawsuit that Van Pelt planned to file once he was released from jail. This testimony suggested that Van Pelt was actively trying to manufacture evidence of his innocence and was willing to involve others in a conspiracy to obstruct justice. The fact that Van Pelt was scheming to create false evidence was presented to the jury as consciousness of guilt, meaning his behavior indicated he knew he was guilty and was trying to avoid conviction. Additional testimony at trial came from Linda Adair and Terry Pate, who worked with Sandra at the Shoney's restaurant in Muscle Shoals. These co-workers could provide information about Sandra's life, her relationship with Kim, and her state of mind before her death. Their testimony helped establish Sandra as a real person with a life and relationships, rather than just a victim in a criminal case. This victim impact testimony is standard in murder trials and helps juries understand the human cost of the crime. Prosecutors also presented evidence about previous relationships or proposals that Van Pelt had made. A witness named Lawson testified about a proposal that Van Pelt had made to him, though the specific details of this proposal are not fully elaborated in the court records. The testimony was admitted to show Van Pelt's plan and intent, suggesting that he had a pattern of behavior or had discussed schemes with others. This evidence was presented as substantive evidence of guilt to demonstrate Van Pelt's state of mind and planning. The prosecution built their case on the theory that Kim Van Pelt had married Sandra with the specific intention of killing her to collect the life insurance money. They argued that the rapid timeline of events, marrying Sandra, taking out a large insurance policy just 3 days later, repeatedly checking on the insurance status, and then Sandra turning up dead just days after the conditional insurance approval, all pointed to premeditation and planning. The location of Sandra's blood in the bedroom where she and Kim slept, the thorough cleaning of the mobile home, the witness observation of Van Pelt's truck backed up to the home with a rug over the railing, and the disposal of Sandra's nude body on a rural road in another county, all suggested that Van Pelt had killed Sandra in their home and then transported her body to dispose of it. The defense attorneys representing Kim Van Pelt faced a difficult challenge given the circumstantial evidence against their client. The case was entirely circumstantial, meaning there was no direct evidence, such as an eyewitness to the murder or a confession from Van Pelt. However, circumstantial evidence can be very powerful when multiple pieces all point toward the same conclusion. The defense likely argued that the state had not proven beyond a reasonable doubt that Van Pelt was the one who killed Sandra. They may have suggested alternative explanations for the evidence, or argued that the timeline and circumstances were not as clear as prosecutors claimed. Van Pelt maintained his innocence throughout the proceedings. The trial took place in December 2006 in Colbert County. Circuit Judge Jackie Hatcher presided over the case. The trial consisted of a guilt phase, where the jury determined whether Van Pelt was guilty of capital murder, and then a penalty phase, where the same jury would recommend either death or life in prison without parole if they found him guilty. During the guilt phase, prosecutors presented all the evidence described above over the course of several days of testimony. The defense cross-examined witnesses and may have called their own witnesses to challenge the state's theory of the case, though the court records do not provide extensive details about the defense case. The jury deliberated for approximately 2 hours on December 8, 2006, after hearing closing arguments from both sides. The relatively short deliberation time suggested that the jury found the evidence compelling and did not have significant disagreement about Van Pelt's guilt. The jury returned a verdict finding Kim Van Pelt guilty of capital murder. In Alabama, capital murder requires proof of murder plus an additional factor that elevates it to a capital offence. In this case, the specific charge was capital murder for pecuniary gain under Alabama Code Section 13A 540A7. Pecuniary gain means financial profit or benefit. The jury concluded that Van Pelt had murdered Sandra in order to gain financially from her life insurance policy. After the guilty verdict, the trial moved into the penalty phase. The jury was now tasked with deciding whether Kim Van Pelt should be sentenced to death or to life in prison without the possibility of parole. In Alabama death penalty cases, the jury hears additional evidence and arguments specifically related to sentencing. The prosecution presents aggravating circumstances, which are factors that make the crime worse and support a death sentence. The defense presents mitigating circumstances, which are factors that might call for mercy or a lesser sentence. Aggravating factors in murder cases can include things like the especially heinous or cruel nature of the crime, vulnerability of the victim, lack of remorse, or danger the defendant poses to society. Mitigating factors can include the defendant's age, background, mental health, lack of prior criminal history, or any other circumstances that might explain their actions or suggest they deserve life rather than death. After hearing the evidence and arguments in the penalty phase, the jury deliberated for approximately 1 hour and 40 minutes on Monday, December 11, 2006. The jury returned a recommendation of death for Kim Van Pelt. The vote was 10-2, meaning 10 jurors believed Van Pelt should be executed, while 2 jurors believed he should receive life without parole. In Alabama, a jury's sentencing recommendation in capital cases does not have to be unanimous, and at the time of Van Pelt's trial, the final sentencing decision rested with the judge rather than the jury. The jury's recommendation carried significant weight, but was not binding. Circuit Judge Jackie Hatcher reviewed the jury's recommendation and the evidence from both phases of the trial. Judge Hatcher followed the jury's recommendation and sentenced Kim Van Pelt to death. The formal sentencing reflected the court's determination that the aggravating circumstances of the murder, specifically that it was committed for pecuniary gain and involved planning and premeditation, outweighed any mitigating circumstances. Van Pelt was transferred to death row at Holman Correctional Facility in Atmore, Alabama, where Alabama houses male death row inmates. As with all death penalty cases, Van Pelt's conviction and sentence were automatically appealed to the Alabama Court of Criminal Appeals. This direct appeal is mandatory in capital cases to ensure that the trial was conducted properly and that the death sentence is appropriate. Van Pelt's attorneys filed numerous assignments of error, arguing that various legal mistakes had been made during the trial that warranted either a new trial or a reduction in his sentence. The Alabama Court of Criminal Appeals reviewed the entire trial record and issued a decision in 2009, affirming both Van Pelt's conviction and his death sentence. The appellate court found that the trial had been conducted fairly and that the evidence was sufficient to support the jury's verdict. The court addressed each of Van Pelt's arguments for reversal and concluded that none had merit. Van Pelt then sought review from the Alabama Supreme Court, which is the state's highest court. The Alabama Supreme Court denied certiorari review, meaning they declined to hear the case, and a certificate of judgment was issued on May 13, 2011. This completed the direct appeal process in state court. Van Pelt had 1 year to file for post-conviction relief, which is a different type of legal challenge that can raise issues not addressed in the direct appeal. On May 10, 2012, Van Pelt timely filed a petition for post-conviction relief pursuant to Rule 32 of the Alabama Rules of Criminal Procedure. In this petition, Van Pelt raised several new arguments for why his conviction and sentence should be overturned. He alleged that the state had suppressed evidence in violation of Brady v. Maryland, a United States Supreme Court case that requires prosecutors to turn over evidence favorable to the defense. He claimed that a juror had given untruthful responses during jury selection, which violated his constitutional right to a fair and impartial jury. He also argued that he had been denied effective assistance of counsel, meaning his trial lawyers had not provided adequate legal representation. The ineffective assistance of counsel claims included several specific allegations. Van Pelt argued that his trial attorneys had failed to adequately communicate with him during the 2 years he remained in jail between his arrest and trial. He claimed that his lawyers did not adequately interview him or discuss important topics including his work history, educational background, his relationship with Sandra, their living situation in the weeks before her death, and his mental state. He also alleged that his trial counsel failed to adequately investigate the capital murder charge against him before trial. Finally, he contended that his lawyers did not adequately challenge the state's case at trial, including failing to communicate to the jury that the case was based entirely on circumstantial evidence, not physical evidence directly linking Van Pelt to the location where Sandra's body was found. The circuit court reviewed Van Pelt's post-conviction petition and ultimately issued a summary dismissal, meaning the court rejected the petition without holding a full evidentiary hearing. The court found that Van Pelt had failed to plead sufficient facts to support his claims, and that even if his allegations were true, they would not entitle him to relief. Van Pelt appealed this dismissal to the Alabama Court of Criminal Appeals. In August 2015, the Court of Criminal Appeals issued a decision upholding the circuit court's dismissal of Van Pelt's post-conviction petition. The appellate court reviewed each of Van Pelt's arguments and found that he had not demonstrated that his trial attorneys were ineffective or that any constitutional violations had occurred. Van Pelt attempted to appeal the denial of post-conviction relief to higher courts. In November 2015, the Alabama Court of Criminal Appeals denied his appeal. He then sought review from the Alabama Supreme Court. In April 2016, the Alabama Supreme Court denied Van Pelt's appeal without issuing a written opinion, meaning they declined to disturb the lower court's ruling. This effectively exhausted Van Pelt's state court appeals of his post-conviction petition. As of the available public records, Kim Van Pelt remains on death row at Holman Correctional Facility in Alabama. His inmate number is Z737, and records show he is a white male born in 1961, making him in his early 60s now. He is described as 6 feet 3 inches tall, weighing 217 pounds, with brown hair and hazel eyes. He has been incarcerated on death row for nearly 20 years, since his conviction in 2006. Alabama has not executed anyone since 2013, so Van Pelt has spent these years in the isolation and harsh conditions of death row while his case went through appeals. He may still have federal habeas corpus appeals available, which would involve filing in federal court to challenge his conviction and sentence on constitutional grounds. These federal appeals can take additional years to resolve. The case of Kim Van Pelt and Sandra Osment Van Pelt represents a tragic example of murder for financial gain in the context of a relationship that had barely begun. Sandra moved from Michigan to Alabama, married a man she had met online, and was dead within 2 weeks. She likely had no idea when she married Kim Van Pelt that he was already planning to kill her for insurance money. The speed with which he took out the life insurance policy and the quick checking on its status suggest that money was his primary motivation from the beginning. Sandra's 3 daughters lost their mother to a senseless and greedy act of violence. The fact that Van Pelt killed Sandra in their own home, the place where she should have been safe, and then disposed of her body like trash on a roadside, demonstrates a cold and calculated approach to murder. The jury and judge who sentenced Van Pelt to death concluded that his crime was among the worst murders under Alabama law. The premeditation involved, the financial motive, and the callousness of killing someone so soon after marrying them all contributed to the decision that death was the appropriate punishment. Whether Van Pelt will ultimately be executed or will die of natural causes on death row remains to be seen, but he will spend the rest of his life in prison for the murder of Sandra Marie Osment Van Pelt, a woman whose only mistake was trusting the wrong person. Before we move on, make sure to subscribe if you're enjoying this breakdown. Moving on to case number 4. Case number 4. Fred Marion Gilreath Jr. was a man from Georgia who was convicted of murdering his wife Linda Gilreath and her father Gerrit Van Leuven in May 1979. He was sentenced to death in 1980 and spent 21 years on death row before being executed by lethal injection on November 15, 2001. The murders occurred during a domestic dispute when Linda was in the process of divorcing Fred and had come to their home with her father to collect her personal belongings. The case involved a violent double homicide where both victims were shot multiple times with different weapons, and Fred attempted to burn the crime scene by pouring gasoline on the bodies. Despite pleas for clemency from the victims' own family members, including Linda's children, the state of Georgia carried out the execution more than 2 decades after the crimes. Fred Marion Gilreath Jr. and Linda Gilreath had been married for 11 years before their relationship fell apart. Linda was originally Linda Van Leeuwen before marrying Fred. Her father was Gerrit Van Leeuwen, and her mother had remarried a man named Dempsey Wolfenbarger, making him Linda's stepfather. The couple had children together during their marriage. By early 1979, the marriage had deteriorated to the point where Linda decided to leave Fred. She moved out of the home they shared in Cobb County, Georgia, and went to stay with her mother and stepfather, who lived in a trailer. Linda began the process of obtaining a divorce from Fred, which meant filing legal paperwork to officially end their marriage. The separation was not amicable. Fred Gilreath made threats against Linda and her family after she left him. He threatened Linda's life directly. He also threatened the lives of both Linda's mother and her stepfather, Dempsey Wolfenbarger. Fred even threatened to burn down the trailer where Linda's mother and stepfather lived, showing that his anger extended beyond just Linda to include her family members who were helping her leave the marriage. These threats created an atmosphere of fear and danger. Despite these threats, Linda needed to retrieve her personal belongings from the home she had shared with Fred, which would require going back to a place where a dangerous man who had threatened her was still living. On the morning of Friday, May 11th, 1979, Linda Gilreath made arrangements to go to the house where Fred still lived to collect some of her personal items and clothes. Linda did not feel safe going alone, so her father, Gerrit Van Leeuwen, agreed to accompany her. Linda was supposed to pick up her stepfather, Dempsey Wolfenbarger, from his workplace that afternoon, which would establish a timeline for when people expected her to return. Linda drove a blue Plymouth Duster automobile that day. Fred Gilreath normally drove a red truck, so the blue Duster would be a distinctive vehicle that witnesses could identify. Linda and Gerrit arrived at the Gilreath home sometime in the early afternoon of May 11th, 1979. The evidence presented at trial would later establish that the murders occurred between 1:30 p.m. and 1:50 p.m. that afternoon. When Linda and her father entered the home, Linda apparently began packing some of her belongings. The house showed no signs of forced entry, meaning Linda likely had a key or Fred let them in, which was not surprising since it had been her home until recently. A suitcase was later found near an end table in the living room, indicating that Linda had at least begun the process of gathering her things before the violence started. At some point during their visit to the home, Fred Gilreath began shooting at Linda and her father. The evidence suggested that Gerrit Van Leeuwen was outside the house when the shooting started, possibly having stepped out to the car or the yard. Fred used multiple firearms that he kept in the home to carry out the murders. The weapons belonged to Fred and were kept at his residence. Linda Gilreath was in the living room when she was shot. Fred shot her 5 times on her right side, using a .30-30 caliber rifle. After shooting her multiple times with the rifle, he then shot her once in the face with a 12-gauge shotgun. The shotgun blast to her face was devastating. Blood and tissue were splattered across the loveseat where she had been, across the carpet, and on the walls of the living room. Linda's body fell and ended up lying on the floor between a coffee table and a loveseat. Gerrit Van Leeuwen, who was a short distance away from Linda when the murders occurred, was shot with 3 different guns. Fred shot him in his right thigh with the .30-30 rifle. He shot him in the left chest with the shotgun. He then shot him twice in the head with a .22 caliber weapon. The use of 3 different firearms on Gerrit and 2 different firearms on Linda showed the sustained and methodical nature of the attack. Fred did not use just one weapon in a moment of rage, but instead switched between different guns as he killed both victims. Both victims died from their wounds. Gerrit's body was found on the floor near where Linda lay. After murdering Linda and Gerrit, Fred Gilreath took steps to try to cover up the crime or destroy evidence. He poured gasoline on and around both victims' bodies. He also poured gasoline on the kitchen floor and created puddles of gasoline near the living room. A green military-type gas can was found sitting by the door to the screened-in porch, which was presumably the container Fred had used to pour the gasoline. The clear intent was to set the house on fire with the bodies inside, which would have destroyed forensic evidence and possibly made it harder to determine exactly how the victims died. However, Fred never actually lit the gasoline on fire, for reasons that were not entirely clear. Perhaps he lost his nerve, or perhaps he was interrupted or changed his plans. Fred Gilreath placed a pink towel over Linda's face after killing her. This detail was noted by investigators who found her body. The reason for covering her face was unclear, but it might have indicated some level of remorse or inability to look at what he had done, or it might have been an attempt to depersonalize the victim. Fred wiped down the weapons to remove his fingerprints. When police later processed the crime scene, they found that the guns bore no fingerprints, which was suspicious since the firearms had been fired multiple times. This wiping of the weapons showed consciousness of guilt and an awareness that fingerprints could link him to the murders. After committing the murders and attempting to stage or prepare the crime scene, Fred Gilreath fled. He took the blue Plymouth Duster that Linda had been driving and left the scene. He did not take his own red truck, but instead took Linda's car, perhaps thinking this would make him harder to track, or because the Duster was already parked in a position where he could quickly leave. Fred drove north from Georgia toward North Carolina, where his brother Mike Gilreath lived and worked in the town of Hendersonville. That afternoon, when Linda did not show up to pick up her stepfather Dempsey Wolfenbarger from work as she had planned, he became concerned for her safety. He knew about Fred's threats and knew that Linda had gone to the house with her father to get her belongings. Wolfenbarger went to the Cobb County Police Station at approximately 5 p.m. on May 11th, 1979, to report his concerns. He explained to officers that Linda was in the process of getting a divorce from Fred, that Fred had made threats, and that neither Linda nor her father had been seen since they went to the house earlier that day. The police took the report seriously, given the history of threats. 2 police officers were dispatched to the Gilreath residence at approximately 5 p.m. When they arrived, they did not see the blue Plymouth Duster anywhere on the property. The officers knocked on the front door and received no answer. They then knocked on a side door to a screened-in porch, but still received no answer. As the officers stood outside, they noticed that a door to the porch and a sliding glass door inside the screened-in porch were both sitting ajar or open. Through these open doors, the officers could hear music playing inside the house. They also smelled a strong odour of gasoline coming from inside the house. The smell of gasoline was concerning because it was not a normal odour to be emanating from a home, especially in such strong concentration. One of the officers looked through the opening into the house and saw a man's body lying inside. When the officer stepped further into the porch area to get a better view, he saw the body of Linda Gilreath as well. The officers could see that both people were clearly dead and that the scene looked like a crime scene rather than natural deaths or an accident. The presence of the gasoline smell added to the suspicious circumstances. The officers secured the scene and called for additional law enforcement and investigators to respond. Sergeant Deal was among the investigators who responded to the crime scene. He found the bodies of Linda Gilreath and Gerrit Van Leeuwen in the positions described earlier. He observed the extensive blood spatter and the gasoline that had been poured. He found numerous items in plain view that were evidence of the crime. He seized a .22 caliber short shell casing, 6.30 30 caliber shell casings, and 2 shotgun shell casings. These shell casings were the spent cartridges left behind when the guns were fired. He found a .22 caliber rifle and a 12-gauge shotgun still at the scene. Fred had apparently not taken these weapons with him when he fled. 2 days later, Sergeant Deal returned to the scene with a search warrant to conduct a more thorough search and recovered another .22 caliber shell casing that had been missed during the initial evidence collection. Before he finished diagramming and processing the crime scene, Sergeant Deal placed a southeastern regional lookout on Fred Gilreath and on the blue Plymouth Duster. This was a bulletin sent to law enforcement agencies in the southeast, alerting them to watch for the suspect and vehicle. The dispatcher for the Sheriff's Department in Hendersonville, North Carolina, received the lookout message about Fred Gilreath. The dispatcher contacted Mike Gilreath, Fred's brother, who lived and worked in Hendersonville. The dispatcher told Mike about the message and the fact that police were looking for his brother Fred in connection with a serious crime. The dispatcher asked Mike to let the Sheriff's Department know immediately if he saw or heard from Fred. This was standard procedure when police believed a suspect might flee to a location where they had family connections. At approximately 7:30 p.m. on the evening of May 11th, 1979, just hours after the murders, Fred Gilreath arrived at his brother Mike's office in Hendersonville, North Carolina. Fred was driving the blue Plymouth Duster that Linda had been driving earlier that day. Mike Gilreath contacted law enforcement, as he had been asked to do, and Fred was taken into custody at his brother's location. When police arrested Fred, they observed that he was intoxicated, meaning he had been drinking alcohol. There were reports that Fred arrived at his brother's place in a disheveled state and actually took a shower with his clothes still on, which was bizarre behaviour that suggested he was highly intoxicated or in an altered mental state. Fred was arrested and extradited back to Georgia to face charges for the murders. Fred Gilreath was charged with 2 counts of malice murder for the killings of Linda Gilreath and Gerrit Van Leuven. The trial took place in the Superior Court of Cobb County, Georgia. Jury selection and trial proceedings began on February 25, 1980, less than a year after the murders. The trial included both a guilt-innocence phase, where the jury would determine if Fred was guilty of the murders, and a sentencing phase that would only occur if he was found guilty, during which the jury would recommend either death or life in prison. During the trial, prosecutors presented the extensive physical and circumstantial evidence against Fred Gilreath. They showed the crime scene photographs depicting the bodies and the blood spatter. They presented the shell casings and firearms that had been collected. They established the timeline showing that Linda and Gerrit had arrived at the house in the blue Duster, and that Fred normally drove a different vehicle, yet Fred was found later that evening driving the blue Duster. They presented evidence that the weapons used belonged to Fred and were kept in his home. They showed that the house had no signs of forced entry, indicating the victims had been let in or had keys. They demonstrated that the weapons had been wiped clean of fingerprints. They established Fred's history of threats against Linda and her family. They proved Fred had fled the scene immediately after the murders and driven several hours to North Carolina, where his brother lived. The prosecutors also presented testimony about the nature and extent of the injuries to the victims. Linda had been shot 5 times with a rifle and once with a shotgun, with the shotgun blast destroying her face. Gerrit had been shot in 3 different locations on his body, with 3 different weapons. The medical evidence showed these were not accidental deaths, or deaths that occurred quickly with a single shot, but rather were the result of sustained attacks with multiple weapons. The gasoline poured on the bodies and throughout parts of the house showed an intent to destroy evidence or burn the victims. Fred Gilreath testified in his own defense during the trial. He told the jury that he did not kill anyone. His story was that he had gone to a liquor store and intended to return to the house, but instead of returning, he just kept driving and ended up in North Carolina. This testimony was not particularly credible, given all the physical evidence and circumstances that pointed to his guilt. Fred claimed he had no memory or explanation for how Linda and Gerrit ended up dead in his house with his weapons, why the blue Duster they arrived in ended up in his possession, or why he fled to North Carolina if he was innocent. During the guilt-innocence phase of the trial, Fred Gilreath instructed his trial counsel, meaning his defense lawyers, to present no mitigating evidence at the sentencing phase. This was an unusual decision, because defendants facing the death penalty typically want their lawyers to present any possible evidence that might convince a jury to spare their lives. Mitigating evidence can include things like difficult childhood, mental health issues, lack of prior violent crime, remorse, or any circumstances that might explain the crime or suggest the defendant deserves mercy. By instructing his lawyers not to present such evidence, Fred was essentially giving up on trying to avoid the death penalty if he was convicted. The jury deliberated on the evidence and returned guilty verdicts on both counts of murder. The jury found Fred Gilreath guilty of the malice murder of Linda Gilreath and guilty of the malice murder of Gerrit Van Leuven. With the guilty verdicts established, the trial moved into the sentencing phase. In Georgia, death penalty cases, the jury must find at least one statutory aggravating circumstance beyond a reasonable doubt before they can recommend death. These aggravating circumstances are specific factors defined by law that make a murder worse and potentially deserving of capital punishment. The jury found 3 statutory aggravating circumstances in Fred Gilreath's case. First, they found that the murder of Linda Van Leuven Gilreath was outrageously and wantonly vile, horrible, and inhuman, in that it involved torture, depravity of mind, and aggravated battery to the victim. This aggravating circumstance applies when a murder is committed in a particularly heinous manner that shocks the conscience. The multiple gunshot wounds, the use of multiple weapons, the shotgun blast to Linda's face, and the attempt to burn her body all supported this finding. Second, the jury found that the murder of Gerrit Willem Van Leuven was outrageously and wantonly vile, horrible, and inhuman, in that it involved torture, depravity of mind, and aggravated battery to the victim. Gerrit had been shot with 3 different weapons in 3 different parts of his body, which constituted torture and aggravated battery. Third, the jury found that the murder of Gerrit Willem Van Leuven was committed while Fred Gilreath was engaged in the commission of another capital felony, specifically the murder of Linda Van Leuven Gilreath. This aggravating circumstance applies when one murder occurs during the commission of another serious crime. After finding these aggravating circumstances, the jury deliberated on the appropriate sentence. They recommended that Fred Gilreath be sentenced to death for both murders. On March 3, 1980, The trial judge followed the jury's recommendation and sentenced Fred Gilreath to death for the murder of Linda Gilreath and death for the murder of Gerrit van Leuven. Fred was transferred to death row at the Georgia State Prison in Jackson, Georgia, where he would spend the next 21 years. As with all death penalty cases, Fred Gilreath's convictions and sentences were automatically appealed to the Georgia Supreme Court. His appellate lawyers raised numerous issues, arguing that legal errors had been made during the trial that warranted either a new trial or a reduction in sentence. The Georgia Supreme Court reviewed the entire record of the trial. On appeal, Fred's lawyers challenged the admission of certain evidence, the jury instructions, the sufficiency of the evidence, and the appropriateness of the death sentences. In 1981, the Georgia Supreme Court issued its decision in Gilreath v. State 247, Georgia 814, 279, SE2D 650. The court affirmed both the convictions and the death sentences, finding that the trial had been conducted properly and that the evidence was sufficient to support the jury's verdicts. The court found no reversible error in how the trial judge had handled the case. After the Georgia Supreme Court affirmed his convictions and sentences, Fred Gilreath petitioned the United States Supreme Court to review his case. He filed a petition for a writ of certiorari, which is a request for the Supreme Court to hear the case. In 1982, the United States Supreme Court denied certiorari, meaning they declined to hear the case. The Supreme Court denies the vast majority of petitions it receives, so this was not unusual. A petition for rehearing was also denied in 1982. This completed Fred Gilreath's direct appeal process. In 1983, Fred Gilreath filed his first state habeas corpus petition in the Superior Court of Butts County, Georgia. Habeas corpus petitions are a different type of legal challenge that can raise issues not addressed in the direct appeal, such as ineffective assistance of counsel or newly discovered evidence. This first state habeas petition alleged that constitutional errors had occurred during his trial. The state habeas process went through multiple courts over several years, as Fred's lawyers raised various claims, and the state responded. Eventually, the state habeas challenges were denied, and Fred's death sentences remained in place. On September 23, 1992, Fred Gilreath filed his second federal habeas corpus petition in the United States District Court for the Northern District of Georgia. Federal habeas corpus allows state prisoners to challenge their convictions in federal court on the grounds that their constitutional rights were violated. This second federal habeas case involved additional factual development of claims and extensive litigation. The District Court eventually denied relief on March 29, 1996, finding that Fred had not established that his constitutional rights were violated. Fred filed a motion to alter or amend the judgment and a request for reconsideration, both of which were denied on March 7, 1997. On September 3, 1997, the District Court granted Fred permission to appeal certain issues to the 11th Circuit Court of Appeals. The 11th Circuit Court of Appeals held oral arguments on April 29, 1998, and again on December 15, 1999, in Fred's case. These arguments gave Fred's appellate lawyers the opportunity to explain why they believe the District Court erred in denying relief. On December 1, 2000, a three-judge panel of the 11th Circuit issued its opinion in Gilreath v. Head 234 F3D 547. The court affirmed the District Court's denial of relief on all grounds, finding no basis to overturn Fred's convictions or death sentences. Fred petitioned for rehearing, which was denied on April 17, 2001. On October 1, 2001, Fred petitioned the United States Supreme Court for a writ of certiorari to review the 11th Circuit's decision. The Supreme Court denied the petition. The mandate of the 11th Circuit was issued on October 10, 2001, formally signalling the end of litigation in the second federal habeas case. With all appeals exhausted, Fred Gilreath's execution could proceed. On October 24, 2001, the Superior Court of Cobb County filed an execution order. The order set a 7-day window during which Fred's execution could occur, beginning at 12 p.m. on November 13, 2001, and ending at 12 p.m. on November 20, 2001. Jim Wetherington, the Commissioner of the Georgia Department of Corrections, scheduled the execution to occur at 7 p.m. on November 14, 2001. Fred Gilreath would be 63 years old at the time of his execution, having spent more than 2 decades on death row since his conviction in 1980. As the execution date approached, Fred's lawyers filed applications with the Georgia Board of Pardons and Paroles seeking clemency, which would be a commutation of his death sentence to life in prison. The clemency hearing was held on November 13, 2001. In an extraordinary development, members of the victim's own family testified in favour of clemency for Fred Gilreath. Christopher Kellett, who was Linda's son and was 8 years old when his father killed his mother, spoke at the hearing. Christopher told the board that if his mother could talk, she would say she did not want Fred to die. Christopher said the family had lost enough and did not want to lose any more. Christopher had reconciled with his father a year before the scheduled execution and had introduced his own children to their grandfather Fred. Christopher, his sister, and their aunt, who was the sister to Linda and daughter of Gerrit, spent 90 minutes with the parole board, pleading for Fred's life to be spared. Despite the emotional testimony from the victim's family members, the Georgia Board of Pardons and Paroles denied clemency on November 13, 2001. On November 14, 2001, as the scheduled execution time of 7 p.m. approached, Fred's lawyers filed a motion for stay and temporary restraining order in the United States District Court for the Northern District of Georgia. They raised claims about alleged problems with the clemency hearing, including the absence of one board member and alleged conflicts of interest of 2 other members. While considering these motions, the District Court granted a stay of execution until 9 p.m. on November 14, 2001. After reviewing the arguments, the District Court denied the motion for stay and temporary restraining order at 9 p.m, finding no basis to halt the execution. Fred's lawyers immediately appealed to the 11th Circuit Court of Appeals. The 11th Circuit issued a stay of execution until 3 p.m. on November 15, 2001, to give the court more time to consider the last-minute appeal. This meant Fred's execution was delayed by approximately 20 hours from the originally scheduled time. On the morning of November 15, 2001, the 11th Circuit denied Fred's appeal and refused any further stay. The execution was rescheduled to occur at or after 3:01 p.m. on November 15, 2001. Fred's lawyers made a final appeal to the United States Supreme Court. The Supreme Court briefly delayed the execution by approximately 30 minutes, while considering whether to grant a stay. When the Supreme Court also denied a stay, there were no remaining legal obstacles to the execution proceeding. Commissioner Wetherington confirmed that the execution would take place at approximately 3:53 p.m. on November 15, 2001. Fred Marion Gilreath Jr. was executed by lethal injection at the Georgia Diagnostic and Classification Prison in Jackson, Georgia, at approximately 3:53 p.m. on Thursday, November 15, 2001. He was pronounced dead shortly after the lethal drugs were administered. Fred was 63 years old at the time of his death. He had spent 21 years and 8 months on death row since being sentenced to death in March 1980. The execution of Fred Gilreath was the 3rd execution carried out by the state of Georgia in less than 3 weeks, making it part of a period of relatively frequent executions in the state. Fred was the 27th person executed in Georgia since the state resumed executions after the death penalty was reinstated nationally in 1976. The method of execution used for Fred Gilreath was lethal injection, which had recently become Georgia's method of execution. Fred was actually the first person to be executed by lethal injection in Georgia, rather than by electrocution. Prior to 2001, Georgia had used the electric chair for all executions, since resuming capital punishment in 1983. The switch to lethal injection was made after the Georgia legislature authorized it as an alternative method, and the state acquired the necessary drugs and equipment. Lethal injection involves administering a series of drugs intravenously that cause unconsciousness, paralysis, and finally cardiac arrest. The case of Fred Marion Gilreath Jr. represents a domestic violence murder that escalated to the ultimate violence when a woman tried to leave an abusive relationship. Linda Gilreath had endured threats from Fred after she left him and started divorce proceedings. Despite taking the precaution of bringing her father with her for safety, she and Gerrit were both murdered when they returned to collect her belongings. Fred's actions that day, using multiple weapons to shoot each victim multiple times, attempting to burn the crime scene, and fleeing to another state, demonstrated a level of rage and violence that the jury found warranted the death penalty. The fact that the victim's own family members, including Linda's children, pleaded for Fred's life to be spared shows the complexity of these cases. Christopher Kellett and his siblings had to grow up without their mother because their father killed her. Yet they eventually reconciled with him and did not want to see him executed. They testified that their mother would not have wanted Fred to die, and that the family had suffered enough loss. Despite these heartfelt pleas, the state of Georgia proceeded with the execution, based on the jury's verdict and the determination that the aggravating circumstances of the crime justified capital punishment. Fred Gilreath spent more than 2 decades on death row before his execution, which is not unusual in modern capital cases, where extensive appeals can take years or decades to exhaust. During those 21 years, he had the opportunity to reconnect with at least some of his children and meet his grandchildren. The long gap between crime and execution is common in death penalty cases because of the multiple layers of appeals that are automatically triggered when someone is sentenced to death. These appeals serve important purposes in ensuring that constitutional rights are protected and that no innocent person is executed, but they also mean that decades can pass before a death sentence is carried out. The murders of Linda Gilreath and Gerrit Van Leeuwen on May 11, 1979, destroyed a family and traumatised the children who lost their mother. The execution of Fred Gilreath on November 15, 2001, closed a legal chapter that had been open for more than 22 years. But it could not undo the harm that was done or bring back the victims. Linda died trying to retrieve her belongings from a marriage she was escaping, and her father Gerrit died trying to protect his daughter. Fred Gilreath paid for those crimes with his own life after spending more than 2 decades in prison awaiting execution. Before we move on, make sure to subscribe if you're enjoying this breakdown. Moving on to the final case of the video. Case number 5. Thomas Robert Lane was a man from Alabama who was convicted of capital murder and sentenced to death for drowning his estranged wife, Teresa Lane, in a bathtub in October 2003. Lane was first convicted and sentenced to death in 2006, but that conviction was overturned in 2010 by the Alabama Court of Criminal Appeals due to constitutional violations related to his right to legal representation. He was retried in 2016 and again convicted of capital murder and sentenced to death. Lane remains on death row in Alabama as of the current records. The case centered on the drowning death of Teresa, a Filipino immigrant who Lane had met through the internet and married, but from whom he was separated and seeking a divorce at the time of her death. Prosecutors argued that Lane broke into the home where Teresa was staying, drowned her in the bathtub, and stole her jewelry, with the motive being to collect insurance money and to free himself to marry another Filipino woman he had met online. Thomas Lane and Teresa Lane were married after meeting through the internet. Teresa was from the Philippines and had come to the United States to marry Thomas. This type of arrangement, where American men meet and marry women from the Philippines or other Asian countries through internet correspondence or international marriage services, was sometimes referred to as a mail-order bride arrangement, though. That term is considered outdated and offensive by men. Teresa immigrated to the United States and married Thomas, establishing her life in Alabama. The marriage did not last, and by 2003 the couple was separated and going through divorce proceedings. Teresa had moved out of the home she shared with Thomas and was living as a roommate with a woman named Pelagia Wilson at Wilson's home on 15th Street in Irvington, Alabama, which is in Mobile County. During the period of their separation, Teresa was afraid of her husband Thomas. Friends and co-workers who knew Teresa would later testify at trial that she had expressed fear of Thomas. She told people that Thomas had beaten her during their marriage. She reported that he had threatened her. The pattern of behaviour suggested a history of domestic violence in the relationship, which is common in cases where a marriage ends in murder. Teresa had taken the step of physically separating from Thomas and filing for divorce, which are often the most dangerous times for domestic violence victims, because the abuser may escalate their violence when they feel they are losing control over their victim. While separated from Teresa and in the process of divorcing her, Thomas Lane had already met another woman from the Philippines through the internet. He was making plans to marry this new woman and bring her to the United States. This suggested that Thomas viewed Filipino women as interchangeable partners he could order through the internet, and that he was eager to replace Teresa with a new wife. However, the divorce proceedings meant he was still legally married to Teresa, which may have been an obstacle to his plans to remarry. Additionally, there were financial entanglements from the marriage that would need to be resolved. Thomas Lane worked and had various interactions with people in his community. Co-workers and acquaintances would later testify about statements Thomas made about women and about his wife. A local Nissan dealer remembered Thomas saying at one point that the only good woman is a dead one. This misogynistic statement revealed Thomas's attitude toward women and would later be seen as relevant to understanding his mindset when he allegedly killed his wife. A co-worker of Teresa's testified at trial that Thomas had asked this co-worker to pass along a threatening message to Teresa. The message was that if Teresa chose not to return to the marriage, she would be sorry. This was clearly a threat meant to intimidate Teresa and suggest there would be consequences if she proceeded with the divorce. On Sunday morning, October 12, 2003, Teresa Lane was found dead in the bathtub of the home where she was living with Pelagia Wilson in Irvington. Pelagia Wilson worked a night shift as a babysitter and had been gone from the home overnight. Wilson returned to her home at around 10 a.m. that Sunday morning after finishing her all-night babysitting job. When she entered the home, she made the horrifying discovery of finding her roommate Teresa dead in the bathtub. Wilson testified that when she found Teresa, she was completely submerged under the water in the bathtub. Wilson immediately contacted authorities to report the death. Dr. Leszek Krostowski, a forensic pathologist, was called to the scene. He went to Wilson's home and removed Teresa's body from the bathtub for transport to the morgue. The following morning, Monday, October 13, 2003, Dr. Krostowski performed an autopsy on Teresa's body to determine the cause and manner of her death. What the autopsy revealed made it clear that this was not an accidental drowning or a natural death, but rather a homicide. Dr. Krostowski found multiple pieces of evidence that Teresa had been violently attacked before she drowned. Krostowski determined that the cause of Teresa's death was drowning. He based this determination on several findings. First, Teresa had foam around her mouth when her body was found, which indicated that she had water in her lungs at the time of death. This foam is created when water in the lungs mixes with air and body fluids and is expelled through the mouth, which happens in drowning cases. Second, Teresa had petechial hemorrhaging in her eyes. Petechiae are tiny broken blood vessels that appear as small red dots. When they appear in the eyes, they indicate that the person was asphyxiated or deprived of oxygen. In a drowning, the lack of oxygen causes these blood vessels to rupture. However, Dr. Krostowski found much more than just evidence of drowning. Teresa had suffered several blunt force impacts to the top and back of her head. These impacts cause subdural hemorrhaging, which means bleeding underneath the tough outer membrane covering the brain. This type of injury indicates that Teresa's head had hit or been hit against a hard surface with significant force multiple times. Dr. Krostowski concluded that Teresa had hit the bathtub with the back of her head numerous times. The injuries were consistent with her head being forcefully struck against the hard porcelain or enamel surface of the bathtub. Teresa also had bruises on her right shoulder and on her chest area near the base of her neck and by her clavicle or collarbone. Dr. Krostowski testified that these bruises indicated that she had been held down. The location and pattern of these bruises suggested that someone had used their hands or body weight to push down on Teresa's upper body, holding her in place. When combined with the other evidence, this indicated someone had held her down in the bathtub. Additionally, Teresa had extensive bruising that Dr. Krostowski identified as defensive wounds. She had numerous bruises on both of her forearms, on both of her elbows, on her right thigh, on her right knee, and on her right ankle. Defensive wounds are injuries that occur when a victim tries to protect themselves or fight off an attacker. The pattern of injuries on Teresa's arms and legs indicated she had been struggling against someone, trying to defend herself or escape. Some witnesses would later testify that Teresa had scratched her attacker during the struggle, leaving marks on his legs. Based on all of his findings, the foam around her mouth, the petechial hemorrhaging in her eyes indicating asphyxiation, the blunt force trauma to her head from hitting the bathtub multiple times, the bruises on her shoulder and chest from being held down, and the defensive wounds on her arms and legs, Dr. Krostowski formed an expert opinion about what happened to Teresa Lane. He testified that the evidence indicated Teresa had been pushed down into the water in the bathtub and held under the water until she drowned. He stated his conclusion without the slightest doubt. Someone had forcibly drowned Teresa Lane after a struggle in which she fought back and tried to protect herself. When police investigated the scene at Pelagia Wilson's home, they looked for evidence of how the perpetrator had gained entry to the house. The home did not show obvious signs of forced entry through broken windows or damaged doors, which might suggest Teresa had let someone in, or that a key had been used. However, investigators did find something significant. There was a chisel mark inside the home's front door frame. This mark appeared to be from a tool that had been used to pry or force the door open in a way that would not leave as much obvious damage as breaking a window or smashing a lock. A forensic specialist would later examine this chisel mark and compare it to tools that belonged to Thomas Lane. Police quickly identified Thomas Lane as a suspect in his estranged wife's death. On the day after Teresa's body was discovered, Monday, October 13th, 2003, Thomas Lane was arrested and charged with her murder. As investigators built their case, they gathered evidence connecting Thomas to the crime. One particularly important piece of evidence involved a chisel. In Thomas Lane's truck, police found a chisel. Forensic expert Scott Milroy, who specialised in tool marks and impressions, examined both the mark on the doorframe at Pelagia Wilson's home and the chisel found in Thomas Lane's truck. Milroy testified that the chisel from Lane's truck matched the mark on the doorframe. This evidence suggested that Thomas had used his own chisel to force entry into the home where Teresa was staying in order to kill her, which would make the murder a capital offence because it was committed during a burglary. The state's case against Thomas Lane was built on circumstantial evidence, physical evidence, and witness testimony about Lane's behaviour and statements after the murder. One of the most damaging aspects of the case against Lane was his own behaviour and statements on the day of the murder, and in the days and weeks following. Sergeant McRae of the police department had contact with Thomas Lane and would later testify that he did not inform Lane about any of the specific details of how Teresa died. Despite not being told these details by police, Thomas Lane somehow knew facts about Teresa's death that only the killer would know. On the evening of October 12, 2003, the same day Teresa's body was discovered, Thomas Lane told multiple people that Teresa had been found dead in the bathtub earlier that day. He told several friends and neighbours about her death. Strangely, he provided two different possible explanations for how she died. He said she had either had an aneurysm and drowned accidentally, or she had been held underwater and murdered. The fact that he described the two exact scenarios that would explain the physical evidence, drowning that could be accident or murder by being held underwater, was suspicious, since police had not released these details. Lane told these people that he would probably be blamed for Teresa's death. He then asked several people to provide him with an alibi by saying they had seen him at home at the time of Teresa's death that morning. Every person he asked refused to lie for him. The fact that Lane was asking people to lie about his whereabouts showed consciousness of guilt. Even more damaging to Lane's case was evidence that he attempted to collect on Teresa's life insurance policy on the very afternoon of her murder, just hours after her body had been discovered. Ron Pierce, a chaplain with the Mobile County Sheriff's Department, testified at trial about a phone call he received from Thomas Lane at approximately 4:30 p.m. on the afternoon of October 12, 2003. During this call, Lane asked Pierce for paperwork that he could present to Walmart so that he could collect on Teresa's life insurance policy. Teresa worked at Walmart and apparently had a life insurance policy through her employment there. The fact that Lane was already trying to collect the insurance money within hours of his wife being found dead, before she was even buried, or before funeral arrangements were made, suggested that financial gain was a motive for the murder. Most people would be grieving or in shock upon learning of their spouse's death, not immediately calling to start the process of collecting insurance money. After Thomas Lane was arrested and jailed awaiting trial, he was housed in the Mobile County Metro Jail. During his time in jail, Lane apparently made statements to other inmates about the murder. Several inmates would later testify at trial about confessions or admissions Lane made to them. Wayne Jewett, who was Lane's cellmate in October 2003, testified that Lane confessed to him that he drowned his wife in the bathtub. According to Jewett, Lane told him he had used a screwdriver to gain entry into Wilson's house, though forensic evidence suggested a chisel was used. Jewett testified that Lane said Teresa had struggled and she scratched his legs up, and that Jewett had actually seen the scratches on Lane's legs. This detail about the scratches was consistent with the defensive wounds found on Teresa's body and suggested a violent struggle had occurred. Kevin Szabo, who at the time of trial was incarcerated in a federal penitentiary in Indiana for bank robberies, also testified about confessions Lane made while they were both housed in the Mobile Metro Jail. According to Szabo, at one point Lane said he could not believe he drowned his damn wife. During another conversation about what people are willing to do to get money, Lane said, "Tell me about it. The insurance money got me in here." Lane then told Szabo that he had thought he was the beneficiary on Teresa's life insurance policy, and that he was angry when he found out that he was not actually the beneficiary, because he had wanted to get the money to pay for a new mail order bride. Lane described the details of the murder to Szabo, saying that he had held Teresa down with his leg and she had scratched him, and he held her in the bathtub under the water until she drowned. Another inmate named Bruno, who had been Lane's neighbour before both men ended up incarcerated, testified that Lane had confessed to murdering Teresa. Bruno testified that while he and Lane were discussing Lane's case, Lane mentioned to Bruno that he had told a few people in the chapel, or church at the jail, that he did it. Lane reportedly said he was not too concerned about having made these admissions because the confessions happened in the sanctity of the church, and he believed they could not be used against him due to some kind of religious confidentiality. This showed that Lane had confessed to multiple people in the jail, including in religious settings. There was also testimony from an eyewitness who had seen a vehicle near Pelagia Wilson's home around the time of the murder. This eyewitness was a deceased auto mechanic, whose testimony was read to the court since he had died before trial. The mechanic testified that he saw Thomas Lane's bright green pickup truck at the scene during the time of the homicide. However, the mechanic's testimony had a problematic aspect that the defense emphasized. When it came to the physical description of the person who climbed out of the truck, the mechanic said he was certain the person was not of Thomas Lane's stature. This created some doubt about whether Thomas was actually the person driving his truck that day, though prosecutors could argue someone else might have borrowed the truck, or that the witness was mistaken about the physical description. Thomas Lane's first trial began in 2006 in Mobile County. He was charged with 2 counts of capital murder. The first count alleged that he committed murder during the course of a burglary, based on the evidence that he forced entry into Pelagia Wilson's home using the chisel. The second count alleged that he committed murder for pecuniary gain, meaning for financial benefit, based on the evidence about the life insurance and his desire to free himself to marry another woman. The trial included testimony from Dr. Kostobski about the autopsy findings, from forensic experts about the tool mark evidence, from Teresa's friends and co-workers about her fear of Thomas and his prior abuse and threats, from jailhouse informants about Thomas's confessions, and from witnesses about Thomas's suspicious behaviour after the murder. The jury in the first trial found Thomas Lane guilty on both counts of capital murder in 2006. The trial then moved to the penalty phase, where the jury had to decide whether to recommend death or life in prison without the possibility of parole. By a vote of 8-4, the jury recommended that Lane be sentenced to life imprisonment without the possibility of parole for his capital murder convictions. This meant that 8 jurors favoured life and 4 favoured death. However, at that time in Alabama, the jury's sentencing recommendation was not binding on the judge. The trial judge, Joseph Rusty Johnston of Mobile County Circuit Court, had the authority to override the jury's recommendation. Judge Johnston overrode the jury's recommendation for life and instead sentenced Thomas Lane to death. This practice of judicial override, where judges could impose death sentences even when juries recommended life, was controversial and would later be eliminated in Alabama, but it was still legal when Lane was sentenced. Thomas Lane appealed his conviction and death sentence. His lawyers raised multiple issues on appeal, including challenges to the admission of evidence, jury instructions, and other trial proceedings. One issue that proved successful was a claim that Lane's constitutional right to counsel had been violated. The Alabama Court of Criminal Appeals reviewed the case and found that Lane's defense attorney had been unjustly removed from the case before the trial began. This removal violated Lane's Sixth Amendment right to legal representation and his right to counsel of his choice. Because of this constitutional violation, on February 5, 2010, the Alabama Court of Criminal Appeals reversed Thomas Lane's capital murder conviction and death sentence and ordered a new trial. This meant that Lane's 2006 conviction and death sentence were thrown out, and he would have to be tried again. The retrial of Thomas Lane took place in 2016, a full 10 years after his first conviction. The testimony began in March 2016. The state presented essentially the same case they had presented in the first trial, with evidence about the autopsy findings, the tool mark evidence, testimony about Lane's abuse and threats toward Teresa, the jailhouse confessions, and Lane's suspicious behaviour, including asking for alibis and trying to collect insurance money. The defence again attempted to poke holes in the witness testimony, particularly focusing on the eyewitness who said the person who got out of Lane's truck did not match Lane's physical stature. The defence argued that someone else could have committed the murder. They also challenged the reliability of the jailhouse informant testimony, as such testimony is often viewed skeptically because inmates may have incentives to lie in exchange for benefits in their own cases. After closing arguments in the second trial, the jury deliberated for approximately 3 hours before reaching their verdict on March 15, 2016. The jury found Thomas Lane guilty on both counts of capital murder. He was convicted of murder during an act of burglary and murder for financial gain. Teresa's family members who attended the trial expressed relief at the verdict. Miriam Mahoney, Teresa's sister, said they had been waiting 6 long years for the trial and could not handle it anymore. She and John Mahoney, Teresa's brother-in-law, said they were happy with the results and praised both the prosecutors and the defense attorneys for their work. The sentencing phase of the second trial took place following the guilty verdict. During this phase, both sides presented evidence related to whether Lane should receive the death penalty or life without parole. A psychologist named Rosenzweig testified for the defense. She stated that although she believed Lane's troubled past led to his brutal murder of his wife, she believed he would not be a threat to others around him if allowed to remain in jail for life without parole. She testified that as far as she was able to determine, Tom had never thrown a punch at anyone in his entire life, despite the evidence that he had beaten and threatened his wife during their marriage. This testimony was meant to suggest that Lane was not an ongoing danger and that life in prison would be sufficient punishment. After hearing the evidence during the penalty phase, the jury had to decide whether to unanimously recommend death. Under Alabama law, aggravating circumstances must be proven beyond a reasonable doubt before a death sentence can be imposed. During the penalty phase, the jury unanimously found that Lane committed the murder while engaged in the commission of, or an attempt to commit, or flight after committing, or attempting to commit a burglary. This finding established the aggravating circumstance that would legally support a death sentence. Unlike the first trial where the jury voted 8-4 for life in prison, the second jury's recommendation regarding sentencing was different. After considering all the evidence in the penalty phase, this jury recommended death. The trial judge, Charles Graddick of Mobile County Circuit Court, followed the jury's recommendation. Judge Graddick sentenced Thomas Lane to death on both capital murder counts. This sentence was imposed in 2016, 10 years after Lane's first death sentence, and 13 years after Teresa's murder. Thomas Lane again appealed his convictions and death sentence after the second trial. His case went through the Alabama Court of Criminal Appeals, which affirmed his convictions and death sentence. Lane v. State, 327, So, 3D, 691. The Alabama Supreme Court denied certiorari review in November 2020. The United States Supreme Court also denied certiorari in 2021, declining to hear Lane's case. This meant that Lane's convictions and death sentence became final in November 2020, when the Alabama Court of Criminal Appeals issued a certificate of judgment. On November 16, 2021, 1 year after his convictions became final, Thomas Lane timely filed a post-conviction petition under Rule 32 of the Alabama Rules of Criminal Procedure. In this petition, he challenged his convictions and sentence, raising various claims of constitutional violations. Lane requested that the court appoint counsel to represent him in the post-conviction proceedings. On April 5, 2022, the state responded to Lane's petition and moved to have it summarily dismissed without a hearing. On April 18, 2022, the Circuit Court summarily dismissed Lane's post-conviction petition, finding that he had not stated valid claims for relief. Lane, through his appointed counsel, moved for reconsideration and appealed the dismissal. As of 2024, Lane's post-conviction appeals were still ongoing in the Alabama courts. Throughout his legal proceedings, Thomas Lane has maintained his innocence. In letters he wrote to the media outlet AL.com immediately after his 2016 conviction, Lane said there was a loose end that should be explored further. He claimed that there was another man in Irvington who was saying there is someone on death row because of me, referring to Teresa's murder. Lane suggested that someone else committed the murder and that he was wrongly convicted. However, the physical evidence, the tool mark evidence linking his chisel to the break-in, his knowledge of details about the crime, his attempts to establish false alibis, his immediate efforts to collect insurance money, and his multiple confessions to fellow inmates all pointed to his guilt in the eyes of the juries who convicted him. As of the most recent available information, Thomas Robert Lane remains on death row at Holman Correctional Facility in Alabama. His inmate number is Z726. He has been on death row since 2016, following his second trial and conviction. While his post-conviction appeals continue through the courts, he awaits a potential execution date if all his appeals are unsuccessful. Alabama has resumed executions in recent years after a period without any, so Lane could face execution if the courts deny his remaining appeals and the state proceeds with setting an execution date. The murder of Teresa Lane represents a case of domestic violence that escalated to the ultimate act of violence when a woman tried to leave an abusive marriage. Teresa came to the United States from the Philippines seeking a better life through marriage to an American man. Instead, she found herself in an abusive relationship that she tried to escape by separating and filing for divorce. Despite taking steps to protect herself by moving to a friend's home, she was tracked down and murdered in a brutal attack, where she was forcibly drowned in a bathtub after a struggle. The evidence showed that her husband, Thomas, could not accept that the marriage was over and that she would not return to him. Rather than let her move on with her life and proceed with the divorce, he chose to kill her, apparently motivated by anger, a desire to collect insurance money, and a wish to be free to marry another woman. The case also illustrates the phenomenon sometimes called murder for hire or murder for replacement, where a person kills their spouse to collect insurance or to be free to marry someone else. Thomas Lane was already in contact with another Filipino woman and planning to marry her when he killed Teresa. He viewed his wife as replaceable and disposable, an attitude reflected in his earlier statement that the only good woman is a dead one. This misogynistic worldview, combined with his history of domestic violence, created a deadly situation for Teresa. The fact that two separate juries, viewing the same evidence in trials 10 years apart, both convicted Thomas Lane of capital murder, shows that the evidence against him was compelling. While the first jury recommended life in prison, the second jury recommended death, and both trial judges sentenced him to death. Whether Thomas Lane will ultimately be executed or will spend the rest of his life in prison remains to be determined by the outcome of his ongoing appeals, but he will never be free for the murder of Teresa Lane. If you enjoyed the video, make sure to subscribe, and I'll see you in the next video.